Good morning, all. This hearing is in the matter of DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi & Company. Lead counsel is Mr. David Holloway. The defendant is represented by Quinn Emanuel, and lead counsel is Mr. George McPherson. Thank you, Your Honour.
All right, Mr. Holloway.
Good morning. Good morning, Your Excellency. We've got a number of matters to deal with today. This is obviously the consequentials hearing, and there are two applications, one from either side. I've set out my position on sequencing in my skeleton, if Your Excellency's had a chance to read it at paragraph 5. So my suggestion was that we dealt with what I've called the immediate consequential matters first, being costs and publicity, and then we deal with the applications. We would suggest ours be dealt with first because it was made first and foreshadowed several months ago, and the defendants be dealt with second as it was made late, but I'm not. It's in Your Excellency's hands really as to how you want to proceed. That was just my suggestion.
Okay, well, I don't mind. I don't mind if you take your submissions in the order of your skeleton, and Mr. McPherson takes his submissions in the order of his skeleton. I think I'm sufficiently mentally gymnastic to be able to handle that.
Well, that would be, then I would just make submissions on everything first, and Mr. McPherson follow. I guess the only wrinkle with that is that the amendment application was made by the defendant, so he may want to move that first. But I really don't think it matters. I haven't got too.
Sorry, the amendment to the judgment.
Yes.
No, I just take it in the order of your skeletons. That's the easiest way for you, and I'll give you each a reply.
Right, and then I think the last thing then would be timings. I mean, I think we've been listed for a full day on this. I'm not sure whether or not that's going to be needed. I didn't want an indication of when to start. Really. So
no, again. I don't think it should take a full day, but you have me. Do it in your own time. I'm sure you'll both be sensible about the use of time. I'm quite relaxed.
Your Honour, can I raise one point before Mr. Holloway starts?
Yes.
It's just the point about confidentiality. There's clearly an issue on the agenda about the continuing confidentiality of the proceedings, and it was just to say that I do have some submissions to make about that, and on that basis that Your Honour should make an order that this hearing, at least until you've heard those submissions, should be in private.
No, I think that's right. Until, well, these proceedings are private until I order otherwise.
Yes.
Yes, I'm not against that at all. Of course,
Well, that's the basis we've been working on so far. Okay.
Thank you.
So off you go, Mr. Holloway.
So I'll start then, Your Excellency, with costs, and in a nutshell. There's a section A of my skeleton, but really we should be entitled to our costs of these proceedings. In summary, because there has been a clear winner, and that's us. As I said, it doesn't matter. I mean, Your Excellency has issued a judgment summarising these principles in the Al Buhaira case recently. It doesn't matter, and it shouldn't matter, that we didn't win on every single point. This has been intensively litigated over 7 months. So we would ask for a global costs order, notwithstanding that the first defendant was successful in persuading Your Excellency to award security for costs, notwithstanding the fact that one of their applications, that one was successful. So our position is we would like a global order for cost. The principle of costs should follow the event. Now, Mr. McPherson's position is that you should kick this off until final trial, and we say that that's not right, because there has been a clear winner in these intensively fought proceedings, and there's a number of reasons. The first defendant hasn't made clear whether they're going to participate in a trial yet or not. Their position up to now has been that they may not do, or that they're protesting the jurisdiction of the court. The Hong Kong courts, obviously, this is not a case where we've had an injunction pending the trial, and the matter is going to come before the trial judge in Hong Kong. The Hong Kong court will not have any authority to order the cost of these proceedings. So this is a completely different situation from the kind of situation where an interlocutory injunction has been made pending the injunction being made final at the trial. This is a completely separate type of scenario. This is a freezing order which was hard fought, and those are the cases show that those are treated in the same way as every other interlocutory application, and the costs follow the event, the loser pays. We rely on the Dos Santos case for that. I could turn you to that, because I think that's sort of encapsulates what we're saying.
You've set out the passage in your skeleton, haven't you?
Yes. So it's a paragraph 116.
Well, I've got it in your skeleton at paragraph 12. I mean, that's the bit that you're
yes, indeed. Yes, so it's 116, 117, 118. And the key is that this is a freezing order. And the passage at 118 is not an interim injunction, because it will never be made final. So this is what differentiates the kind of order that we've got from a standard interlocutory American cyanamide type injunction. It's not the case that you've made an injunction which is temporary and might or might not be made final at the final trial. This injunction stands until the court orders otherwise, and it's got nothing to do with the trial, really. And that's, I think, the policy behind that distinction. This is a case that we've cited a bit later, and it's mentioned in Dos Santos, but we want to rely on Cancri investments.
Okay, where do I find that?
This is at page 2553. So this is
your authority. That's your authority bundle.
Well, actually, this is just the final bundle. I'm giving the reference to the hearing bundle for today. Has got all the authorities in there.
Okay, well, that's really unhelpful, because the bundle that I've downloaded only goes to 2547. I mean, there's been a flurry of late authorities, which has not been helpful. Also, your authorities bundle wasn't tabbed in any way, so I've tabbed it all up myself.
I think the reason for that was that we put everything in the bundle, the final hearing bundle with the index on it. So we're sorry for that, but it's
well, I always download the bundle and start preparation. So any late additions really put me in difficulty.
Well,
I do get rather annoyed by late additions, I have to say.
I'm so sorry. This is the only case I think that we've put in late, so it should.
So where do I? Is it in your authority? Is it in your authorities bundle?
I'm afraid it's not.
Oh.
Your Excellency.
Okay, so well, I'm now going to have to go online. Okay.
It is just one, so I do apologise, and that will be the end of it.
Yeah, it's really a pain. Okay, what can I do here?
It was sent to the registry with our authorities bundle yesterday. It just, but it
Yeah,
with a separate PDF.
I have to open a new window. Right. All right, log on. This is why I don't like using the bundle on the website. It takes so long to load. Right. Okay. So what page?
It is 2553, Your Excellency, and I'm sorry again for this.
2553. Well, you'll know for a future.
Yes.
Okay.
I can just invite you first, Your Excellency, to read the head notes at page 2553. And I think that summarises.
Okay, let me read that.
And
So I'm still reading.
sorry.
Okay, I've skimmed that.
And then I just the points that I wanted to just develop from that. At point 5 in the head note, the defendant has a choice whether to resist the continuation of a freezing order and cause the cost of return date to be incurred, and particularly paragraph 7, little subparagraph 7, the policy reasons behind this distinction, which is if the cost of the continuation of a freezing order were generally reserved, the defendant would have a free shot at opposing the continuation of a freezing order on a good arguable case ground. And that's developed in paragraph 27 of the judgment, but it's really not developed much further. But that's a point that we say is important here. Defendant should not get a free shot forcing us to incur very substantial costs, and then say, well, let's think about it later in case we might win ultimately a trial. So paragraph 27 makes that point just further down, and that's at 2562.
Yeah, I have that.
And also there's a world of a substantial difference between cost later and cost now. That's we say very relevant here. And paragraph 28, just further down, also relevant here. If a respondent launches an attack on a freezing injunction on the basis of non-disclosure and that attack fails, as it has here, it's not unreasonable that the respondent should pay the costs of that attack. And paragraph 30.
Mm-hmm.
Just 6 or 7 lines down. I will be in a better position than the trial judge to deal with the costs of these issues. So that's the distinction here. In a non-freezing type injunction, it would be an injunction which may or may not be reviewed at trial, and the trial judge would take a view on those costs, but that doesn't apply here. So the important difference is whether it's a freezing order or not, and it in my submission, it makes no sense at all to try to suggest that your order is not a freezing order. Now I'll just give you one more authority on that, which hopefully is in the right place, which is Stephen G. And he talks about, you should find this at page 2015 of our authorities bundle. Follows the same numbering as the main bundle, so it should be in both with the same numbering on it.
Yes, don't worry about that. Just tell me which paragraph of G it is, because I have put tabs in.
Yes, it's paragraph 1036.
Okay, I've got it.
And he talks about just basically this nomenclature of freezing orders and freezing injunctions, and it's these paragraphs, subparagraphs 1 and 2 there. Just above it, the terms freezing injunction or freezing order should not obscure the purpose of Moreva injunction or the principles governing the Moreva injunction, but it's the second part really, paragraph 2. A freezing injunction can also be granted outside the scope of the court's Moreva jurisdiction. This includes an injunction granted in aid of a proprietary claim or in respect of trust asset which has gone missing. And then it carries on the terms freezing injunction and freezing orders. Let's see, should not be obscure the purpose of the Moreva.
So where are you looking?
And I'm just checking what I'm looking at, maybe further over the page. I don't know. So yes, just this paragraph underneath the second one. After the CPR, an injunction not based on proprietary ground continues to be called a Moreva injunction. Words understood by lawyers. It can be appropriate for clarity to use the words Moreva rather than the general expression freezing injunction to distinguish between Moreva relief and relief granted in support of a proprietary claim or in respect of trust assets. And then there are differences between those kinds of injunction, but the words freezing injunction are used, which are used in the rules of court to make applicable rules and proceedings for orders which meet the definition, regardless of the ground on which the relief is granted, because they share the ultimate purpose, which is restraining a party from dealing with assets. So,
sorry, are you reading or submitting?
I'm reading, and then just sort of vaguely summarising at the end, but I'll read it. The rules which apply are different. That's true, but the definition, regardless, the definition, regardless of the ground on which the relief is granted, and then it quotes the CPR, has in both 1 and 2 the words restraining a party. So I think that my submission, the thrust of that is the word freezing injunction can apply to both Mareva injunctions and injunctions made on a proprietary basis to freeze assets or to restrain the use of assets. Those are often called proprietary freezing orders. There is some sort of overlap between the definitions and sometimes a misuse of the definition, but the misuse is normally that Mareva can sometimes be mistakenly used to cover both. But I think that passage from G makes it clear that both kinds of order are freezing orders, and that's the distinction. They have that peculiar aspect to them, that they do the same job. It's just the assets are different. Maybe the rules are slightly different, but they're both types of freezing order. So that's my submission. Now, going back to our case, we have just a complete overlap here. We have an order that is both a Mareva injunction and a proprietary freezing order, but it's certainly very different from an interlocutory injunction pending trial. This is a freezing order. There's no argument on it in my submission, and in that case, costs should follow the event as per the Dos Santos case. The defendant has fought every aspect of it tooth and nail. They attacked the freezing order. They made a freestanding application to set it aside. They attacked it on non-disclosure grounds, which Your Excellency rejected, and they really shouldn't be allowed to do that and not have to pay the costs. We were required to pay costs. We were required to give security for their costs, and that ultimately the justice of it is on our side. So even if Mr. McPherson could convince you that this is not a freezing order, you would still have a discretion to order costs in our favour. There's no rule barring you to do it. The cases that he will cite to you all say that they're all interlocutory injunctions. They're not freezing order cases, and the rationale behind them is that, you know, if an interim injunction is made, and it may or may not be made final at the final hearing at the trial, you would not be in a position to know who the ultimate winner is until the injunction has been made final or not. But in this case, that just doesn't apply. There is a clear winner. So that I'll leave the submissions there. He'll have to convince you that it isn't a freezing order, basically. And the second submission then is we'd ask you to make an order on the indemnity basis in this case. Because we submit the defendants behaved unreasonably throughout the conduct of this litigation. And I've set out a number of categories of submission on that, but the first is the evidence. And at every twist and turn, Your Excellency has been pointing out on a regular basis the problems with the evidence that has been submitted. A large volume of evidence has been submitted, and we've been put to the cost of picking through it. And at each point, it is being found to be inconsistent. These are Your Excellency's words, and we put them in the skeleton, but internally inconsistent, evasive, opaque. You've said that the evidence raises issues of bona fides. You made the finding about the porting exercise and the backdated documents. I know Mr. McPherson will be making submissions on that, but the judgment as it stands says that it is not easy to envisage an explanation of this that is consistent with an honest explanation. You've also said that the evidence appeared to be calculated to obfuscate and confuse, riddled with internal inconsistencies and anomalies, and that has led to a huge increase in the costs of the proceedings to date. So, I mean, at every hearing, what we've had is the defendant making arguments on full and frank, pleading points, legal points, and pretty much ignoring the evidence. And it's been left to my side to pick through what's being produced and point out the problems with it. With Your Excellency's done it more effectively than we have, but we've had to spend a lot of time digging through this asset disclosure, explanations of what happened that just don't simply add up. Now, even if they had simply said, okay, we've got a legal argument and we've got a non-disclosure argument, this could all have been done in March. But in fact, what they said is we didn't have an arguable case. And they said, we're going to put detailed evidence in, we're going to convince Your Excellency that everything was done normally, and we've had wave after wave of this, and it's done nothing of the sort. So just in terms of the approach to evidence, that has taken this case way beyond the norm. Secondly, we say that this order was made in February, at the end of February. It was actually notified to the defendant on that date by the court. And we're sitting here over 7 months later, and we say the disclosure and information provisions still haven't been complied with. We're left with an incomplete asset picture and no satisfactory answers as to what has happened to the money. So that I'll be coming back to in terms of the orders that we're making for compliance, or we're seeking to be made on compliance. But that's a second factor. And even if there is a belated now agreement to cooperate or to comply with the order, but that begs the question, why now? I mean, if they understand that they have to provide these explanations and documents, then that's an admission that the order required them to do that back in February. Now, they say the timetable was short, but that's 7 months ago. And at each point, we've had 10, I think 4 affidavits, 6 witness statements, and still not proper compliance. So that's the second reason why I'd asked for indemnity costs, but obviously I'll need to develop that later in the compliance submission, which I'll probably come to later today. Third, the delay. Again, this is the the return date hearing in July was the third time this was listed for a final hearing. The first hearing, the defendant said that they were going to convince you that the case was, I can't remember the word that Mr. Montague-Smith used. He said it was reckless, and that we'd gone way over the line in making this application, and that they hadn't had enough time. They were going to convince you. That hearing went at length at a rehearsal of arguments that ultimately were unsuccessful. So that was a hearing, an adjournment at the defendant's instigation. The second hearing, again, they said they needed to put expert evidence in, was adjourned at the last minute, very late. That expert evidence didn't take them anywhere. So we're here 7 months later, we don't have a public judgment yet, and we don't have compliance with the order. That's another reason that takes this out of the norm. I've said it before, but if they had relied on legal arguments and non-disclosure, that could have been done in March. The rest of it that they put in didn't help them. It increased the costs and it went nowhere. So we say that's another factor that takes this case out of the norm. Then we get to full and frank disclosure. And, well, again, Your Excellency, in the judgment, I think we disagree about how many allegations were made. I think you counted 10, and I counted 13, and I had to respond to them. They all, we had made a mistake, one of them, and I'll come back to that, but none of it rose to the level of matters that were going to lead you to set the orders aside, and most of it, you've summarised it, you've described it as an avalanche of trivia. I stand by my calculation of 13 allegations because I think there were 8 in the first affidavit, there were 2 in the second, there were 8 in Mr. Britton's third affidavit, which the application covered. There were 2 new ones in his fourth affidavit, and there were 3 new ones in Mr. Montague-Smith's skeleton argument coming up to the hearing. So that leaves my count at 13. They weren't all pursued at the hearing, but they shouldn't have been. Many of them were very trivial. So that's another point that takes this out of the norm. Securitization, I hesitate to talk about it again because every single hearing we've been forced to re-argue this point. But the defendant consistently tried to persuade to proceed with this securitization and to get the court's blessing for it, and refused to agree not to do it until you made it absolutely clear that your views on it, which have been expressed quite clearly in the judgment. We've spent a lot of time in each of these hearings dealing with an attempt by the defendant to securitize these assets and to get the court's blessing for it when it was obvious that this was not the right thing to do. We've had to get an ex parte order preventing that from happening. That was complained about at length, but it was never set aside. And then I think final point, the allegations of dishonesty were made without any evidence against Ms. Lee, Mr. Sun, and we say those should never have been made. They were just not really matters that should have been part of this application, and they were groundless. And I'll include with that the allegation that the mistake in our affidavit was a deliberate attempt to mislead the court. Your Honour's found that was not right. I suggest that that's another matter. So I'll leave the submissions there on indemnity costs, but we say we would like an order for costs in principle on the indemnity basis, and moving on, we'd like to apply for a payment on account of costs. Now, I hesitate to ask, but has Your Excellency seen Ms. Jabala's 7th statement and cost schedule that we rely on?
Seen is a good word.
I won't ask what a bad word is then. I'll take you to the schedule. It's at page 2548. Sorry, that's the witness statement. And the witness statement just simply confirms the costs that have been incurred. And the schedule accompanying it sets it out in detail.
Okay, I have it separately.
Okay.
Right, the schedule. Yes, I have the schedule in front of me.
Bear with me, Your Excellency, I'm just getting it in front of me. So you'll see that the total fees that we've had to incur are 2.177, 2,177,000. That breaks down as around about 1.7 million in lawyers' fees.
Yes, the schedule. Yes, schedule A is in dollars, and then the breakdown is in both currencies. Yes, I see.
Yes.
But actually, both isn't it?
Yes.
Both.
Yes, it is in both, and we've broken down by application and by hearing, and you can see a bit more detail on the next page.
But you're not asking for me to assess these.
No, we're not asking for you to assess it. We're just telling you what we've incurred on, so that you can have an idea of that when you're calculating what would the appropriate payment on account should be if you're minded to order a payment on account.
Well, the standard order is 50%, isn't it?
Yes, and that's what we're asking for. There are cases that say that that's not a hard rule, and that you've got to just make a reasonable and conservative estimate of what the cost could be. I think we could have asked on that basis for a higher figure, but the guideline is 50%. The point of that is that there's a significant cushion there if anybody suggests that those costs should be assessed down or for whatever reason. But we're not doing that exercise today. So I'm giving you the global figure and asking for a payment of account in the normal way of 50%. And the final point on costs, Your Excellency, is that we have been required to pay security for costs, as Your Excellency will know, in May. And we did pay that security, $650,000 US. We should now have that money returned. These proceedings have concluded today. The application previously made for permission to appeal has been refused. So any further applications will have to be made if Mr. McPherson and his clients feel there's any other basis for things like that. But those were paid as security for costs in case the first respondent were to win these proceedings and they've lost. So we should get it back.
And do you know? I can ask Mr. McPherson in due course, but do you know whether there's been an application to the Court of Appeal?
I know that I've not seen one, but I don't know if.
Okay, no, but I mean, just in terms of security, obviously the Court of Appeal would have jurisdiction to.
Yes, we will be asking, should you be minded to make that payment of account, that any future appeals be conditional on that being paid, and the reason for that is to stop this one-shot, free shot business. We weren't allowed to have a free shot. We had to give security for their costs.
I don't think I have jurisdiction to.
No, you don't.
To fetter the Court of Appeal.
No, we were not asking for that, of course, but we would be asking the Court of Appeal in the event that there is a further application from Commission.
Okay.
That's what I have to tell you on costs. So I will then move on to publicity. And what I'd say about that is that this goes together, if you like, with the collateral use application, but there are two ways of doing the same job, or one has an impact.
Well, that's what I wanted to ask you, because it seemed to me that if the proceedings were public, you wouldn't need the collateral use order, would you? Because effectively every document has been read by and shown to the court.
It probably depends on the way you frame that publicity order, but I guess that not every document has actually been read to the court, given the voluminous exhibits that have been put in. It may be that there's something that.
But I mean, they are exhibits to affidavits, all of which have been.
Yes, that's all correct. But there are other aspects of disclosure, bank statements and so on, which we didn't put, not all of which have made it into bundles and exhibits. So there may be things that just weren't, that have been disclosed but not exhibited.
Yeah.
And it's really a belt and braces job, because you're quite right, Your Excellency, that if you're going to order that the proceedings, the witness statements and exhibits, most of that work is done. But I think the collateral use is probably for
then you're asking me to allow you to make collateral use of documents I haven't seen. Well, if I have seen them, the next hypothesis, if they were if the proceedings were public, then those documents would be public. But if I haven't seen them, then they wouldn't fall within that. So in other words, so it must be that you're asking me to make an order in relation to documents I haven't seen.
Well, I guess that may be right. I think the purpose of asking for it is we don't know what you're going to do on the price, if number one. Number two, it's really for the avoidance of doubt. It's just to make clear that permission is given for this particular use, so no one could turn around for any reason and say you weren't allowed to do that. So it's
I see that.
They do go together. I do accept that, and if, I mean, the proceedings have been heard in private, so it sort of doesn't follow without an order from Your Excellency that everything in the proceedings has become public, because they weren't read in public, if you like. So there is a little bit of a anomalous position here. I guess we just need clarity on it from both perspectives. I'll take instructions on whether that point is going to cause us any difficulty on the residual bits. But yeah, I think in terms of privacy, we're looking for an order that the proceedings generally are to be made public, including the previous hearings, orders, judgments, and the documents submitted in the hearing. And we would say that is normal. That reflects really the normal position in a freezing order. So what normally happens is that the ex parte hearing is in private, and then one often sees after the return date, the hearings pop up on YouTube and the orders and judgments all become published on the basis that the return date was a public hearing. Now, we had thought in March that that's the way that this would go, that the initial hearing was going to be in private, but after that, everything would become public.
But I found it too complex to do that.
Yes, and we accept that it wasn't as neat and tidy in that in March, because obviously the return, it was the first return date hearing and nothing was decided, and Your Honour gave the direction that things should be in private. But we say that there's no longer, the reasons that you gave for that no longer apply. What you said was that, I think it's in paragraph 6 of your reasons in March, was that proceedings were at a very early stage and that the first defendant hadn't yet had an opportunity to defend itself. But that's no longer the position now. We've had 3 hearings, we've had 10 affidavits, we've had lengthy arguments on everything. So we say those reasons don't apply. The normal rules that the ex parte hearing would be in private, they're there to protect secrecy, that they don't apply. So we're falling back on just the standard position of open justice. And we put the authorities in. I think Mr. McPherson cited them as well. There's no dispute that that's a strong presumption in the law, and we don't see any reason why that should be departed from. We think that this case should be the same as Sandra Holding, Carmen, the Byju's case, which I'll come back to. There's nothing in the interest of justice making this private, and to be honest, this has really been delayed overly by the first defendant, and to the sort of slightly odd position that the Hong Kong court is not allowed to see your judgment and be aware fully of what's been said. So we'd say there's no good reason to depart from the principle of open justice. I think Mr. McPherson talks about the allegations, that would cause problems for the first defendant, but the allegations are public. The Hong Kong proceedings are public. That's no basis that you're a defendant in a fraud claim. There's no basis that this should all be kept secret. So there was nothing really in that. We've never really seen any reason why it should be private. Our position is it should have been public from July onwards. But there we are. So I'll move on to collateral use since I'm on this theme. Just in case, these, in my submission, these do go together. So what the claimant really needs is permission to use the documents, the witness evidence, and so on for related proceedings with the purpose of getting their money back and finding out where it is and so on. So the collateral use undertaking, shall I take you to that first? I mean, I think it's a standard form wording, but it was amended to include the Hong Kong proceedings and the Singapore arbitration with.
I'm familiar with that.
And the purpose of that was obvious. I mean, this whole case is in support of those proceedings, and there's no issue with that. It's perfectly plain why we needed to use the information. Now, it's not. I mean, I'm not sure it's actually contested by the defendant now that we should be allowed to use this further. There's a slight disagreement, but I think there's a slight disagreement about the terms of the order. But really, I think what the defendant's skeleton argument is saying is if you are minded to release from the undertaking, then they're happy to agree it on certain conditions. So I'm not quite clear whether it's accepted or not. So I wanted to take you through the principles behind the law on this.
Well, let's. Well, I mean, they're very helpfully set out by His Excellency Justice Lemaire in the recent case. But why don't he? Since you're waiting to hear what Mr. Macpherson really says about that, leave it to your reply.
All right.
I mean, what I'll do is I'll allow you a reply, and then I'll allow Mr. Macpherson to reply, so that
that's fine.
I get both sides.
Yes, so we'll rely heavily on that case, and we, to be very brief, that case is there's very little difference between that case and this case, and it was made public. Collateral use was granted. Costs were ordered by the judge. But anyway, it is an extremely helpful judgment. Or costs were reserved to the final return date hearing to be considered by the judge. It hasn't yet had its final return date.
Yes.
So
let's leave that over until we've heard from.
Yes. And then I'll just get to the scope and the order. It's at page 12 of the bundle. So, and we're looking at paragraph 4. It's at page 16, sorry, the order is at page 12, paragraph 4 of the order. If I can just pick up on, I think there are only 2 areas of dispute on the draft order, setting aside the principle. The first, I think, is paragraph A. The defendant says that's too general. So there's no dispute about 1, 2, and 3, little numbers 1, 2, and 3. But the defendant says that there shouldn't be a sort of more general provision, any jurisdiction in support of the relevant proceeding. And then the second, I think, area of disagreement is in paragraph B. It's not the principle of assisting with inquiries and so on, but I think it's amongst other things, it is contested that that's too general as well. But we say it needs to be general. By the very nature of this case.
Yes.
We may need quickly to act to use the information. We may need to act quickly to take steps to protect our position, and it doesn't make sense to have to keep making applications to the court in this kind of scenario where monies are being traced across jurisdictions and so on. So we can't, it's impossible to set out every possibility here. There needs to be some flexibility in it. And if one looks at the Byju's case, that's exactly what was decided in that the same argument. The defendant in that case said, well, you have to be specific, and a general permission was given. I can show you that from the order in Byju's case.
Yes.
It's 1724, I hope.
I've got it separately.
Yes.
Okay, 1724. Okay, I have 1724.
Yes, it's just paragraph 1 on 1724. It is hereby, at the bottom of the page, the claimant has permission to use documents and so on, and then A and B. A talks about US proceedings, and then B, civil proceedings in any other jurisdiction in support of or related to the proceeding. That's really what we're looking for here. The same thing, as long as it's related to the proceedings.
But we don't have amongst other things.
We don't have amongst other things, but that's a separate that's a separate objection, I guess. But it's the same objection, really. I mean, it's there needs to be flexibility in this. We cannot sit here and say, and it really doesn't really make sense to have to keep coming back to court. Then the second, I think the second point, not a principle but practical point that the defendants complain about is that, well, you need to set out every document that you want to use in a schedule, and it's not specific enough, and that we say is well, it's not true, but it would be wrong to require that. I'll take you again to Byju's case because His Excellency has also dealt with that objection. It's paragraph 79 to 83, and that's 1741. Just 79 is the real crux of it. So
PDF 113. Yeah.
So he says there's no rule that says you have to list things exhaustively in a schedule. The overriding requirement is that the documents be described with sufficient clarity and specificity to enable the court to identify the scope of the permission sought and to assess whether the legal test is met. So we say that that's wrong. That's an attempt to kick the can again. I think everybody knows what we're asking here, and the documents, the witness statements, the exhibits, all of them do have schedules, and we ought to be able to use them. I don't think we need a separate application, document by document. I think that's unrealistic. And again, there was no schedule in the Byju's case, but that was a point that was raised. So that's what I had to tell you on publicity and collateral use. Unless there's any questions on that, I'll move on to compliance. So the starting point, and we do this at every hearing, is the terms of the order itself. And we're looking at 14.1, 14.2, 15 and 16. I won't take you again to that, but it's a complaint that we've raised at every hearing. We say every part of that has not been complied with. We don't have a complete asset picture, number one. We don't have a complete and accurate account of onward dealings, and we don't have a complete and accurate account of the ultimate beneficiaries or the holders of the monies. So I think this is a point that has come up at every hearing, and I mean, if we can, it's been summarised, I think, in Rita Jabala's 6th witness statement from paragraph 39 onwards. So that, I think, is page, sorry, page 39.
What page of the bundle?
So it's page 39, I believe. Of the
Paragraph 13 then.
Well, I mean, if you go further back, actually, page 37, paragraph 46 onwards.
Sorry, bear with me. I haven't.
Yes, I'm sorry for giving you the wrong.
6 is it's Jabala 6.
Yes.
Okay, which starts at 28.
Yes, and then.
So where do you want to go to? Paragraph 39.
Well, I was probably going too far back there, but paragraph 46, I think we can start with.
Okay, 46. Bear with me. Where is it? 40s. Page 37.
Yes.
Yep.
So we had the various accounts from Mr. Britton, and we picked up, and you picked up in the judgment, Your Excellency, that there are various different accounts. And then we're just recounting this. I'm not going to take you to all the correspondence, but we complained as long ago as in March that there hadn't been proper compliance with the order, and we had to apply in May. I'm skipping through this quickly because I don't want to recount the history in excruciating detail, but we made an application in May, and one of the things that was blatantly outstanding is that they hadn't even given us the bank statements that we needed to help work out where the monies had gone, and then we got redacted bank statements, and we had to make an application to get full information. And at that hearing in May, and the reasons that you gave for ordering that, you actually made it plain that you felt that paragraph 14 had not been complied with at that stage, and your findings are set out in paragraph 55 of Mr. Jabala's 6th statement. So we're looking at.
I've got it.
So basically, you're making the point that we've been making, that we don't have an account of the onward dealings, and what they've given us is random documents, unexplained, in no apparent order, a document dump, and no audit trail, paragraph 63. And you also said back in May, at paragraph 70, that the idea that they hadn't had enough time to do it is something that they might have been able to justify, say, in March, but not in May. So that's the history of it. It was in May, the court had decided that there was non-compliance. And we say it really is the same today. We don't have a clear picture of the assets. We don't really have a clear picture of the onward dealings or the ultimate beneficiaries. And Mr. Ballas summarised it here. So from paragraph 61 onwards, this is why we're here today. So we've got what we've done is there's a schedule to this witness statement, a number of schedules which pretty much summarise the position. Schedule A.
Where do I find that?
That's just at the back of the statement, so it's
got it.
Page,
yes. Okay, it's page 52.
This is, if you like, an overview of what's wrong. And can I just skip through these schedules one by one just to tell you what they are, and then we can come back to them a little bit in more detail. But Schedule A really sort of sets out what's wrong with what they've given to date, and why each paragraph of 14.2, 15 and 16 remains, they remain in non-compliance of it. But some more detail in the other schedules, which might be a bit more illustrative. Schedule B, page 28.
Schedule B is 55.
So that is a schedule listing over 100 transactions. So we've looked at transactions over $100,000, and there's 100 of them that we don't know who we still don't know who the beneficiary is. And when you add it all up, it comes to $230 million. So that's a huge gap. We have been asking since March for
Right. Two figures. There's 327 and 233. So you haven't repeated the header across the pages. Sorry, I've got to go back to the beginning to find what the header is.
Yeah, no, I apologise.
Debit amount, US amount. So what's the difference between debit amount and US amount?
I think some of them are in different currencies. So not all of you. Some of them are in AED, some of them are in USD.
Okay, so if it's all converted to USD, it's approximately 234.
Yes. So we've put the exact figure in because that's what appeared on each statement, or each statement, but you have to convert them all. So that's 233 million, and we had been asking since March for the missing payment transaction repeat summaries or payment certificates from the bank. My bank sends me one of those for every transaction that I do, But they didn't supply them. They wouldn't supply them in March. Now they say they will supply them, but that's $233 million of unexplained transaction. And skipping to Schedule C,
page 62. Yep.
This is a schedule of payments made from the first defendant's other bank accounts. So you remember there are accounts with Mashreq, Emirates, MBD, Adib, but the first defendant has other bank accounts, and this schedule shows that a huge amounts of money were being paid from other accounts of the first defendant into those accounts. So there's a huge amount of circulation of money in and out of the accounts, which just hasn't been explained or accounted for at all. So what, if I could just make it simple, what their expert FTI tried to do is look at payments. When the money came into a bank account, they tried to look at where it went. And when it's gone, they stopped their analysis. What we had no idea about is that money was going from one account to the other and out to other Aria entities and back into the accounts of the first defendant. So what we got is just simply a very, very first blush of what the first, route of the money was. It doesn't talk about where it was recycled, and it doesn't take into account when it came back. So in terms of who the ultimate beneficiaries are, we've just, huge amounts remain unknown there, and it hasn't been explained properly.
Okay, and that's 276 million.
Yes.
276.5 million. 276.5 million. Okay.
Schedule D.
Schedule D.
That's at page 73, and there are significant payments to individuals that we have uncovered from our analysis of the bank statements that were never mentioned in the explanation given by Mr. Britton. So there are payments to himself, there are payments to
4.2 million.
Yeah, there are payments to himself, and then Schedule 2, or Section 2 of the schedule, there are payments to Peter Williams of around $900,000. I believe that person, you may or may not remember, was involved with carbon resilience. That was not explained. That was never, Mr. Britton was supposed to, or the first defendant was supposed to say, who are the ultimate beneficiaries of this money? This was never mentioned. We've had to dig this out from combing through bank accounts. Likewise, Amanda Murray, another person never mentioned before, Oleg Levchenko, at page 82, 185,000, and further on David Gangel. No, it doesn't. It may or may not matter what these payments were, but Mr. Britton's account was supposed to tell us where the money went. We've had to uncomb this ourselves, and then Schedule E is something that Your Excellency picked up on in the judgment. Payments to First Digital Trust and Legacy Trust, and there's a huge amount of confusion about the redemptions and the numbers don't add up. The numbers in Mr. Britton's affidavits and FTI's evidence just aren't consistent. We've extracted this figure from the bank statements. There are various passages in your judgment, where you've made it clear that you don't understand how these redemption payments are supposed to add up. I think at one point you say it just doesn't make any sense. Well, we have identified from these statements a figure that just doesn't tally with the other evidence.
That's around 90 million.
Yes, I mean, there's no dispute that some redemptions were made, but the figures each figure is not in the affidavits. That they're not. They don't.
I have a recollection of a figure being said as 64 million at some point.
Yes, I remember that number. I can't, hand on heart, can't remember which version of that it is. But the figure that we've got is higher than.
Yes.
And you've also said that when you were collating the redemption statements to the subscription documents, they didn't make any sense. They didn't follow logically from what they should do from the other documents. So it's, if it's being said monies are being paid in redemption, we need to know how much, when, what for, which shares were redeemed, which entity investments were redeemed, which coupons have been paid. Now, we shouldn't have to be doing this. This is what Mr. Britton should have been doing at the beginning. And again, I mean, that just echoes from the cost arguments that I've made.
I mean, there is a difference between you as to whether any coupon was ever paid, isn't
there? Yes, I'm not sure. I think there's a difference as to which coupons were, or which redemptions were for which.
No, not redemptions, coupon.
Coupons, I believe, I remember that I'll have to.
I thought it was your case that no coupon was ever paid, whereas it is the first respondent's case that some coupon was paid.
I'll have to. I'm afraid I'll have to go back and double check that, but it doesn't. I mean, the detail of it is. We don't have a clear picture of what the first defendant's case is from these documents and from his affidavits and from FTI's evidence. They all
let's
say.
Go to Schedule F at 93.
And Schedule F, yes, this I think we raised a little bit at the hearing, but there are payments, unexplained payments that we've picked up on here that were never mentioned to IG Limited, which is a DIFC trading platform, to FTX. You have to be very familiar with them. North Dimension, these are significant payments. And Alameda Research, these are companies that North Dimension and Alameda Research are companies affiliated, we believe, to FTX. Now, we don't know, we weren't told about these. We've had to find them. We've had to extract them from bank statements. But the point was that Mr. Britton was supposed to tell us where the money had gone. And we don't know what those payments or any of those were for. Were they investments? Did something come of those investments? The payments to Oleg Levchenko and Peter Williams, were they loans? We shouldn't be the ones having to do this. Now there are a couple more points that I want to make here. After the judgment, Your Excellency, I think you made it clear that you wanted the defendant to send us everything that FTI had received, that we had not received. It became clear that FTI had received some documents that were not shared at the final hearing and not before the court. And there was some discussion about that, and Mr. Britton filed, I think, his 5th affidavit, and we got those documents. But what we got there were 529 documents, and some of those were payment receipts, the kind of document that tells you more detail about a payment that a bank statement does. And there's just no reason why those documents should not have been shared by Mr. Britton at the beginning. We've been asking for those kinds of documents for March. Now, the defendant acknowledges this and apologises for it. Ms. Overden, in her 5th witness statement, apologises, calls it an oversight, says it wasn't deliberate, and she also says that those documents FTI were not able to review them in time, and they were not shared. But my submission, that's totally unacceptable. I mean, these are obviously relevant documents. Whether FTI had time to review them or not, there's no excuse for them not being shared with the claimant. It really, Your Excellency was alive to the point that there were additional documents in play, but it really shouldn't be up to you or to me to point out that when we're asking someone to put an affidavit in telling us where the money is gone, you can't sit on documents like that and give them to your expert and not put them in the hearing. And I think you may have picked up on this from the SCAL, but there's one document in particular which raises further questions, I submit, which it's called a payment itemization summary. I don't know if Your Excellency picked up on that in the skeleton or the documents, but I'll take you to it now.
I saw a reference to it. I've not read the document itself. Where do I find it?
I mean, the detail's probably not the most important thing, but I'm going to show it to you. It's at page 106. So this is what it says it is. It's a payment itemization summary, but it runs to 17 pages, and it has hundreds of entries in it. Now we don't know who produced it, so we've said, the provenance of this document is unclear. The defendant objects to that. They say it's denied that the provenance is unclear, but they don't say who produced it. I think they do imply that this was a schedule produced by the defendant in the sort of course of his preparation for the asset disclosure list. But the problem with it is it doesn't, again, they say FTI didn't rely on it, but the problem is it's inconsistent with FTI's report. It's inconsistent with Mr. Britton's affidavits. There are new beneficiaries in here, which we've never seen before. And really, again, I think something you said back in March, it raises more questions than it answers. Now, again, the defendant accepts that this list is different from the one in the affidavit and in FTI's evidence. And they say, well, FTI never relied on it, so it doesn't matter, I think. But in my submission, that's completely extraordinary. The idea that this was sent to FTI when it purports to be what's Mr. Britton's supposed to do in an account, in affidavit, and it's inconsistent with his affidavits, and it's inconsistent with what they say, and they never read it, and it was never shared. I think that's very, very suspicious, and it really does raise question marks about. Well, it raises more question marks about Mr. Britton's evidence. It raises questions about FTI's evidence. Again, we're back in a scenario where we are finding out by combing through exhibits and so on what the story is, and Mr. Britton isn't doing that. Now, he said in March, I think, that he had a team of 7 people working day and night to comply with this order, but we're 7 months later, and it's we're sort of running out of road in terms of these inconsistent explanations and documents. So this I'll probably come back to what we want in the draft order, but I just want to sort of make it clear that this isn't a further disclosure application. It isn't what the defendant tries to say, that it's some kind of audit. We're asking Mr. Britton to do what he's been promised to do, what he was ordered to do in March. And we floated this after the judgment, Your Excellency, and I think it was in the context of we are minded that Mr. Britton is in contempt of court with this non-compliance, and we will be seeking to take that further. Your Excellency suggested that an application was appropriate if we were going down that road, and I don't make any apology for that. It is perfectly proper to give notice. We've given repeated notice that the defendant is not complying with this order, and if they don't comply, we will be taking the matter further. The point of this application is to give a last opportunity to comply with the order that was made in March, and to try and explain why that is needed, and what needs to be done. And I think I think I'll leave commentary on the provisions of the draft order to reply, because you may want to discuss this further. But just one point, we will be seeking, if this order is granted, that we don't want another report from FTI. We don't want further expert evidence on this. We don't want what the defendant calls a tracing exercise. We want Mr. Britton to explain why his affidavits are inconsistent with each other, and to give a full account of the onward dealings and the ultimate beneficiaries, and produce the documents that are relevant to that. We will conduct our own analysis of that, but the purpose of this is not. Again, it's a can-kicking exercise. Oh, we haven't had enough time to do it, they say. We will do it, but we'll get FTI to do it. Well, we say that's inappropriate. It should be the first.
But he doesn't have to do it personally. I mean, he could have assistance from FTI.
Of course, he can do what he likes, but he has to. Yeah.
You're saying he's the person who has to depose as to the truth of it.
Yes, and
so that he could be cross-examined on that if necessary.
Yes,
and any sanctions applied if it's not true.
That's correct. And given that the inconsistencies are inconsistencies in his own affidavits, on the porting exercise, on all those things, that it is appropriate that he give the affidavit explaining them. And I should add that something that we put in the skeleton that hasn't made its way into the draft order, but we'll be we would request that the explanations given reflect the position at the time when the affidavit was supposed to have been done, as well as at the time of the second or the subsequent affidavit. So it's a request that the proper compliance be given so that there are no gaps. The full picture should be given as of March and as of the date of the subsequent affidavit. I'll leave that topic then for now, and I'll move to the final one, which is the application to amend Your Excellency's judgment.
Well, I mean, this is one really for reply, isn't it?
I'm happy to take it that way if you wish. I did raise that at the beginning. I have no issues with that.
Okay, well let's do it that way, because the timing is convenient. You've been precisely 90 minutes, so let's take a break now until 20 to 9 England and 20 to 12 Dubai.
Great.
Okay, thank you. Right. Mr. McPherson.
Your Excellency, I will, at your invitation, take the issues in the order in which I have dealt with them in my skeleton.
Yes, of course.
I'll start with the issue of confidentiality. This was a matter that Your Excellency reserved to this hearing to determine whether there should be continuing confidentiality hereafter, and clearly there is a relationship, as has been discussed already, between the issue of confidentiality and the applications relating to the judgment amendment and also collateral use, and that's why I'm dealing with this issue first. Essentially, there are three options for the court. The first is total privacy, that is, maintain privacy over the proceedings, including the judgments. The second is partial privacy, which would involve releasing only the judgments into the public domain. And the third is no privacy at all, and that would involve releasing judgments, transcripts, and any other documents referred to in the proceedings. Now, our primary position is we invite Your Excellency to order option one, or to continue the existing confidentiality order. Your Excellency held that at the time of making that order that there were good reasons for granting privacy at the outset of the proceedings, and those reasons remain valid now. In the alternative, if Your Excellency does not accept that, then we invite you to order partial privacy, so that the judgments are released subject to the judgment amendment application, and we say that that strikes the right balance between protecting the parties' legitimate private interests and open justice. And let me develop those points. We accept that the prima facie position is that proceedings are held in public. That's RDC Rule 35.2. That is the starting point, but we are not at that starting point because the court has already made a decision that the proceedings be held in private. And the question now is whether the proceedings should no longer be private. And therefore, the court needs to be satisfied that the reasons for the court ordering privacy no longer apply. So let's start with those reasons. In fact, there were two reasons we would suggest. The first is what Your Excellency said when the application was made that the first return date hearing should be a public hearing, and that was an application made by my learned friend. And it's at page of the main hearing bundle. I don't know if you have the main hearing bundle available.
Yeah, I think I do. Bear with me. Do I have it in this? Yeah, I can get it up if you just give me for a second. Sorry about that. I should have had it up. Right, come on. 2nd of July. Yes, I now have it. Sorry about that.
Thank you. So the page I wanted to take you to is 1270.
Yep.
And that is a passage from the transcript from the March return date hearing. And you'll see that Mr. Holloway says, my understanding was that an ex parte hearing would be heard in private, but not necessarily the return date. And you say in response, no, I think this should be held in private because frankly, no decision has been taken on the merits, and the potential for reputational damage and the impact on other proceedings, matters that are being dealt with on a purely contingent and interlocutory basis, far outweigh, it seems to me, the interests of an application like this being held in public. So that was the basis on which at the beginning of that hearing, the privacy order was made. And the issue identified by you was that privacy was justified because of the potential for reputational damage. And that issue in authority, there is an authority which I don't think we need to go to, but for your note,
case, yes.
It's the Arquam case.
Yes.
Yes. And the point there, obviously the context is different because it's a particular context of FMT tribunal proceedings, but the issue, the question that is posed is whether a publication, whether a public hearing would cause significant and disproportionate harm to legitimate business interests. That was the question that was posed, and that we say is in effect the question that you were asking yourself at that point, or at least it included that question, and you were answering it in the positive at that stage. So that was the first reason, and then the second reason was the one which you've been taken to, which is the one that appeared at paragraph 6 of your reasons. I don't need to go back to that. It's 1110 of the hearing bundle. But as my learned friend said, you immediately rejected the application for that the privacy of the proceedings be lifted on the grounds that it was the early stages of the proceedings and allegations of fraudulent conduct had been made against parties who had not yet had an opportunity to defend themselves. So in effect, what Your Excellency was saying was that one of the exceptions in Rule 35.4 was engaged, and it falls under the general rubric of the interests of justice. It was in the interests of justice that privacy should be maintained. Now, of course, we accept that we're at a more advanced procedural stage than when that order was made. And we also understand that Your Excellency gave a preliminary indication on the last occasion that you were minded to release the proceedings from the protection of a privacy order. But we do say, and I just want to develop this, that the two reasons that you gave for justifying privacy remain relevant. The first was reputational damage. The publication of these proceedings will undoubtedly cause substantial reputational damage to the first defendant's business interests, and that damage will be significant and disproportionate in the manner contemplated by the Arquam test. The first defendant and Mr. Britton operate in highly regulated financial services industries. Integrity is critical to reputation and ability to trade. And at the highest level of generality, what the court has found is that there is a case to answer that the first defendant has been involved in the fraudulent misappropriation of hundreds of millions of dollars of investor monies. That publication, if that appears in a public judgment, that will lead to wide adverse press and public commentary. We know already from documents exhibited in these proceedings that Your Excellency may recall the Bounty article where Mr. Justin Sun offered a bounty of $50 million in respect of information relating to FDT's involvement. So we know that these matters are going to become public, and matters referred to in the judgments will enter a public space and be disseminated. And the perception will be, rightly or wrongly, that there's no smoke without fire. And in those circumstances, the impact will likely be irreversible. That even if the first defendant ultimately prevails on the merits in Hong Kong, but because of the delay, the damage will already been done. And it goes beyond the first defendant to Mr. Britton personally. That the criticisms that are made are obviously specifically criticisms of Mr. Britton, his evidence, his character, or at least criticisms which bear on his good character and professional standing, and they will affect his professional reputation and standing, and affect also those employed by him who will, as a consequence, be in danger of losing a job. So that there's a wider ripple effect to publication. There's also a related concern that the purpose of the freezing order will be frustrated by publication. It's been carefully structured to permit the first defendant's business to continue to operate. The court was persuaded at the first return date to permit assets caught by the proprietary order to be subject to the ordinary course of business exception. The reference for that is 1128 of the hearing bundle, paragraph 73. And indeed, in the judgment at paragraph 412, that is of the hearing bundle, the page for that is 1573. Your Excellency has said that the order, the freezing order, is not directed to preventing the day-to-day trading of the portfolio or subsidiary companies of DMCC or the fund. It's in all parties' best interest that the trading companies keep trading and thereby do not diminish their value. And so the order is made for the best interests of the claimant. The effect of the negative publicity from the judgment will in fact have the unintended consequence of defeating the purpose of the freezing order, because it will allow the first defendant's business, the business of its subsidiaries, to be penalised and to suffer reputational damage. And so that's the reputational damage point. It's still very much a live issue, and issues will be caused by the publication of the judgment.
So that is an argument for complete privacy.
Yes, that is the argument for complete privacy. The second reason that Your Excellency gave was that an individual or an entity faced with allegations of fraudulent conduct has a right to defend themselves without publicity. The fact is that this is a case where very serious allegations of fraudulent conduct have been made against the first defendant and Mr. Britton. And based on those allegations, the judgment makes very serious findings against Mr. Britton within a short time frame, and based on a confined documentation. I accept that on one view, voluminous documentation has been provided, but on another view, that pales into insignificance in the context of the trial, which will ultimately take place when there's been disclosure from all parties, putting this in context. And indeed, it's a point your Excellency is alive to, and I think paragraph 126 of your judgment, where you indicate the provisional nature of the exercise and the parameters of the exercise you're undertaking. But the fact is that there will in due course be oral testimony, there will in due course be cross-examination of the other individuals involved. And so in that context, these are still allegations, and Mr. Britton and the first defendant haven't had the opportunity that would be afforded to them at a full trial to defend themselves by putting their position forward. And the difficulty of doing so at this stage, of course, and this is a point that you mention in the judgment, it is the deficiency in the pleaded case, the fraud case. You've said that you don't find it easy to understand, that it's obscure, and there's a tendency to elide allegations. And so therefore we do say that the two concerns that you identified as justifying privacy remain. And those are the concerns that led you immediately to resist making the proceedings public. The other point I would make is that the risk from publication of the judgment may be even greater now than it was back in March, because of course, inevitably, in a judgment, and impressively, if I may say so, in the short time available, Your Excellency has marshalled the evidence and made trenchant criticisms based on that exercise. And there is in the judgment a cogency to the criticisms which would not be evident from the mere disclosure of transcripts of proceedings. So on that basis, the publication in a reasoned form of these criticisms means they pose a greater threat than they might have done previously. So that's what I have to say about the submissions in support of total privacy. I absolutely accept, as I must, that there is a strong countervailing consideration that we operate in a system of open justice, and there's a public interest in judgments being made public. And so what we say, if that is the thing that sways Your Excellency, and you find that principle requires information about the proceedings to be released into the public domain, then that information should be limited to the judgments. That strikes the right balance between open justice and the legitimate interest of protecting the first defendant's reputation from significant and disproportionate harm. Again, it's related to the point I've just made, but the judgments are comprehensive, and so they do explain a good deal about the proceedings and allow them to be understood. That's often said to be a concern about what open justice requires, that people looking at these proceedings can understand what's happened. And so we do say that would be sufficient to meet that open justice requirement. But if you go beyond the judgment, the risk is that every single allegation made in transcripts, documents, then becomes public knowledge, and that seriously aggravates the scope for reputational harm. We have, for example, you might remember right at the beginning of this, when my learned friend started talking about ghost assets. We objected to that. We later answered it with detailed evidence, but there it is on the transcript. And the risk is that you make these transcripts available, and because the injunction has been granted, any interested person will draw the conclusion that there's a basis to all of this at any point in the proceedings. And equally, the allegation that the fund is a sham, that they will draw the conclusion that there is a basis to this. And so once you open up the privacy order entirely, that is the danger. The other danger, which is a point that's already been canvassed, is you also compromise the court's ability, potentially at least, and this is subject to what I will say about collateral use, but you potentially at least compromise the court's ability to control the use of documents which have been provided in a private forum. And that's a very important aspect of the court's armory, being able to control the use of documents. Suddenly, all documents potentially will be released without anything further required. And so we do say it's also preferable for that reason for the court to maintain some control. So therefore, if you're not swayed that total privacy is the answer, then we do urge you to adopt the middle ground of option 2. And we do accept that there may be an interim position to this extent, that what has been mentioned is the judgment, the availability of the judgment to the Hong Kong court. And we do accept that, subject to to what I'm going to say about the judgment amendment application, that judgment could be released and should be released to the Hong Kong court, if you were minded to make a total privacy order. But otherwise, we say it's option 1 or option 2, and that's what we invite Your Excellency to order. So that's the overall sort of umbrella submission about confidentiality. What I was going to come on to next was the judgment amendment application, and this the position is that we make this application whether or not the privacy the privacy submissions are accepted on either basis. We say that there is good reason to amend the judgment in the 2 limited respects we've identified. The application notice for your lordship's note is 1428 of the hearing bundle. And you will have seen from my skeleton argument that there are 2 amendments, as I say. And I want to start with the jurisdiction that we're relying on, because there are two different jurisdictions. I think I said 3 jurisdictions in my skeleton, but I think that the best way of approaching it is to say there are two different jurisdictions. The first is the slip rule. That's RDC 36.41. And the second is the court's inherent power to make material alteration to judgments in the interests of justice. And importantly, neither jurisdiction is shut out by the fact of judgment having been handed down, albeit it's been handed down in private. Just by way of context, 2 points. First is that we're not seeking to make an amendment to an order. So there are a number of cases you will have seen referred to in the bundle of authorities where that was the issue, and absolutely where it's not a typographical mistake, amendments to the orders generally tend to be substantive, because clearly it's the court granting relief. And so if you amend an order, often it will be the case that there is a substantive amendment, and that's not going to be suitable for amendment under the slip rule. And that was the position in the King and Wood Mallison's case of Justice Cook, and also the authority R+V authority, the decision of Mrs. Justice Gloucester, as she then was. So we accept if you're seeking to amend an order, really, unless it's purely typographical, then the only route is by way of appeal. But it's not the same if what you're seeking is an amendment to a judgment which doesn't actually impact on the relief that the court has ordered, because we're not launching any challenge to the relief that has been ordered. The second point is that, as I mentioned, this is a case where the proceedings are currently heard in private. So even if the judgment has been handed down, it's not a public document. No third parties will have relied on it. And so until it becomes public, its status, we would suggest, is akin to a draft judgment circulated in confidence. Obviously, there's a whole line of case law about the circumstances in which a draft judgment can be amended and recalled and so on. And actually, we're in something akin to that situation, although I accept it's not the same, and that there are particular considerations that apply to when a judgment has been handed down in private or not. But as I've mentioned, there is a jurisdiction in any event to amend, which I'll just explain now. So just developing the jurisdiction point, the slip rule, it's rule 36.14. The court may at any time correct an accidental slip or omission in a judgment or order. So the first point is it's not time limited. It can take place at any time. It can take place after judgment has been handed down. In fact, the example given in the DIFC court's practice is a correction that was made 6 months after judgment. That's just by way of example. That's at page 384 of the Claimants Authorities bundle. If that's of any interest, we don't need to go to it. The next point is a point made by Justice Cook in the Cook, King and Wood Mallison's case. And again, we don't need to go to it. It's at page 52 of our authorities. That's the freestanding authorities bundle, where he says that the boundaries of the slip rule are not defined, but often it is said that it's about obvious typographical errors. And Mrs. Justice Gloucester said it's about genuine slips or mistakes. And that's the R plus V case, and that's page 319 of the Claimants Authorities bundle. But ultimately, the jurisdiction is limited by the language of the rule. It covers any accidental slip or omission. And so importantly, it also covers omissions. So that's the slip rule. And then the next area, the next jurisdictional basis, which requires a bit more development because it's an inherent jurisdiction, is the inherent jurisdiction to alter judgments. Now, there are two cases that I think are relevant to this. The first is the Crown Mohammed case. Now, this is a case that both parties have referred to in their skeletons. My skeleton at paragraph 15, my learned friends at paragraph 64, footnote 18. And in fact, I have cited the relevant paragraph, paragraph 15. So I don't think I need to take you to the authority.
Let me just go to paragraph 15. Okay.
So this was important to say. This was a draft judgment, but the reason I rely on it is the passage I've underlined, that one of the occasions where it might be appropriate to revise a judgment is where it may contain detrimental observations about an individual, which on the face of it are not necessary to the judgment and appear to be based on a misunderstanding of the evidence. So that is the particular passage I rely on. The important authority for present purposes, because we are in a post-hand-down scenario, is the Court of Appeal case Robinson and Fernsby, which I refer to in paragraph 16 of my skeleton. And I would just like to spend a moment on that. Is it helpful if I give you page references according to the freestanding bundle?
Yes, I have your freestanding bundle. Yes.
Right. So the authority is at page 350 is where it starts. I mean, the facts are not especially relevant. It was about an application under the Inheritance Act for an order for reasonable provision out of a deceased's estate. You get that from paragraph 11. But what happened, as perhaps sometimes happens, counsel wrote to the judge on the receipt of the draft judgment, and that's paragraph 49 on page 363. And on the basis of that letter, the judge invited the parties to make further submissions before the hand down. And that happened. And then the judge handed down a draft judgment, which in fact reversed the conclusion, somewhat to the chagrin of the originally successful party. And that's paragraph 52. But what's important about this case is that there's a very detailed discussion of the authorities pre-CPR and post-CPR, addressing the circumstances in which a judgment can be amended pre and post hand down. So it was a pre-hand down case, but the court went beyond that to consider the post hand down scenario. And the post CPR cases are addressed from paragraph 78, just for your note, and that's on page 378. And the effect of those cases is summarized at paragraph 94, and that's at page 375. And that's the paragraph that we rely on. So perhaps if I could ask you to read that paragraph.
Yes, of course. Yes.
So obviously that makes a number of points, but the important point for present purposes is that, that it recognises that there may be circumstances in which it's not only possible, it's actually incumbent on a judge to make material alterations in the interests of justice. And the example given is what's described as a palpable error in the judgment. And then there's a contrast drawn between the situation where parties are in effect advancing a new case, and that's not that's obviously not something which is suitable to result in an amendment. So that's the jurisdiction. It can be engaged where there's a palpable error in the judgment, and so that then brings me to the first amendment that we're seeking, which is the amendment to paragraph 365. And that, if your lordship, if your excellency has it, it's 1557 of the hearing bundle. And I should say, I should apologise that the reference in the application notice was incorrect.
Okay. I picked that up.
Yeah, good.
1557.
Yeah, so that's 365, and in particular, it is the sentence, the second sentence.
No, I understand
what is under
that.
Yeah,
and I mean,
so,
not that I want to cut you short, but subject to anything that Mr. Holloway may say, I'm happy to refine the word fabricated to created.
Thank you for that indication. I think I would, I would, if I may, just have a go at pushing for my chosen alternative, executed, if only because I think fabricated does clearly, according to its dictionary definition, carry a connotation of dishonesty.
Yes, that's interesting, because I looked, actually, I have a rather older version of the Oxford Dictionary, where it doesn't actually. It is just a synonym for creative. But I accept that the later editions, I mean, if I can tell you my thinking, so that both of you can address this. I'm happy to neutralize it to the extent that I accept that it is undecided and will only be decided at trial as to the intent as between your client and FDT in the creation of the mirror documents. But I'm not willing to go any further than that in the light of my analysis of the difficulties and internal inconsistencies with the documents. So fabricated, I accept, could indicate that your client was seeking in some way to deceive FDT, and there is no evidence upon which I can decide that one way or the other. I have set out in the judgment the differing accounts given as to what occurred. I think I counted 4, but I just set them out against the basis that I think at that part of my judgment I did repeat the formula as I counted. I repeated 15 times during the course of the judgment that this was on a serious issue to be tried basis. So, I'm willing to give you that small concession.
Thank you, Your Excellency. As I say, I will just finish what I was saying, which
yes, I think executed is too neutral in my judgment, but you can try and persuade me otherwise.
Well, I suppose that is the point, that this is on the serious issue to be tried basis, and so we would say that it may be. I mean, it may be. I'm not sure from what Your Excellency said whether what you're simply suggesting is a straight substitution.
Yes,
because because I suppose it may be that once you insert created in that particular sentence without the serious issue qualification, accepting of course that theme is clearly present elsewhere, that it does just create, to use that word, the impression that that there's something more to this that goes beyond, that is less neutral than is desirable, if I may put it that way. And
well, from your point of view, but it's a matter of what I meant.
No, of course, and absolutely, I accept your authorship rights, as I must. But I think the only other point to make is that these documents were not the first defendant's documents. These are documents that they're FDT fund documents executed by the fund and the investors. So.
Sorry, what documents are you talking about?
The subscription, the subscription form.
There's no evidence of that.
I'm sorry, my lord.
So there's no evidence that the original documents were executed by the original investors. I mean, what we have, if you really want to get into the granularity of it, we have subscription documents for shares that couldn't possibly exist. I mean, the shares in DMCC is not a fund. It's not organized as a fund. And so when you talk about B-class shares and so on, it can't issue redeemable shares in that way. So those documents those documents were in relation to shares which, at least arguably, were non-existent.
Yes, well, I suppose that is talking about the original documentation, isn't it?
Well, that's what
As
these were.
opposed
That's what
to
the
the mirror.
subsequent documents were. That's what the subsequent documents were made to replace. So, the argument may well be, well, yes, this regularization process was undertaken when it was discovered that what had originally been done was to purport to issue non-existent shares. I mean, we really don't need to get into that, do we? I mean, that would be more harmful. I mean, I can expand upon that if you like.
No, I'm not. No, I will leave it there. I think that was only in support of the submission as to the connotation of creation, but I accept. I'm not going to push that. I see that it is obviously desirable to do the least possible violence to the text in making this type of amendment. So I'll leave that there. The second point, and I take from what Your Excellency's already said, that the second point, the general amendment, is a different point, and I accept. What we're not doing there is asking for words to be substituted in a limited way. It's a general point, and the
Well,
reason
I think you've got a much more difficult task in relation to the second point, given paragraph 126, as you already referred to, of the judgment, plus, as I said, the 15 occasions in the judgment where I referred to serious issue.
I'm sorry this caused you to do that particular search function exercise, but I obviously did that as well at some point, and I think the only point I wanted to make, which is really a point I made in my skeleton, which is that obviously that introductory paragraph was specifically related to the contractual analysis, which was a document-based analysis that you were conducting, and then you were illustrating the limited nature of the exercise you were conducting. And then later in the judgment, when you are making those provisional findings and adverse comments as to Mr. Britton's evidence, that is in fact a different exercise. And so really it was suggesting that a similar paragraph could be inserted to make that clear, because clearly I accept that serious issue is referred to, but it's going that stage further and saying, well, of course, this may all turn out to be entirely true, what I've been told, but I accept that is a different, a qualitatively different amendment, but that is that is why I say that. So that is, and just to finish, I mean, just to finish on that point, the alternative is, of course, to make clear, and this doesn't engage the same jurisdictional hurdles, is to make clear in a judgment that was, for the avoidance of doubt, that was what you intended. It doesn't need necessarily to appear in this judgment in the way we suggest that the amendment to paragraph 365 would. It could be done in a less intrusive way by just making that clear in a separate judgment, or in the judgment that follows today's hearing. So that's really all I wanted to say about the judgment amendment application. What I was going to come to next was collateral use, and on this, I think it's important to state that the actual practical effect of the parties' differences is limited, as a learned friend has indicated, and it is, as he said, essentially three objections that we take to the scope of the permission sought, and that's at paragraphs 52 to 53 of our skeleton. The first is that the order should identify what documents are covered. The second is that the definition of civil proceedings is too broad. and that it should be limited to specifically identified civil proceedings, actual or contemplated. And the third is that the permission to use documents in government investigations and inquiries should be tied specifically to the relevant proceedings and not capable of applying to the use of those documents for any government investigation or inquiry. But in order to address you on those changes, I do need to address you on the nature of the test, because you've heard submissions about this very recent DIFC authority, which I accept on the face of the order made. It clearly supports my learned friend, but I don't think that the mere fact that the authority has just landed that made this order is enough for him. He needs to go further than that.
Well, it doesn't bind me. It doesn't bind me because it's a first instance decision. So I could theoretically disagree with Justice Lemire.
You could disagree, and I think the other point is that, and a point that's repeatedly made in the cases, is that every case is different in these circumstances, and it's for the judge to be persuaded by the applicant that the particular facts justify release or to a greater or lesser extent from the collateral prohibition on collateral use,
so there's no difficulty with the principle that Justice Lemire exercised. You say the issue is fact sensitive in each individual case.
Well, that is my opening submission. I think there are two respects which are important to identify in which it is distinguishable. The first is, and this is, it may help just to have it up. It's one set. One. Sorry, I'm now.
No, don't worry about it. I can find it. I've got it in front of me.
Okay, it's I'm. Yeah, it was 1722. I'm operating on the bundle pagination. Just so
don't worry. Just give me the paragraph number of the judgment.
So, first of all, it relies on the Eurov case. So
yes, I have paragraph 73.
So that it really is the starting point, and it said that is the reason that the founding basis for the jurisdiction is really what is said in Eurov. But it's important to note that Eurov was a case in which the relief sought was limited to specific proceedings, and it related to a post-judgment context. So it was a different form of relief that ensued in the case of Eurov. Eurov does not support the wide-ranging ground of relief. And the second point is, and this is dealt with at paragraphs 97 to 100 of the Baiju judgment, it is that in Baiju there was evidence before the court of the defendant providing a false and misleading account of DIFC proceedings to a US court, and there was a need for use of the documents in the DIFC, or rather use of documents that had been disclosed in the DIFC in the US proceedings to permit the correction of the false impression. So there was a very specific reason why the use was justified for that purpose, and that is obviously given as one of the reasons why the collateral use prohibition can be relaxed. And there's no evidence to that effect, of course, in this case. But the starting point, and it's a point I made in my skeleton, and I'm sure Your Excellency has it, but it's a curiosity, at least to my mind, is that although we are in a situation where there has already been a relaxation of the prohibition, that was not something on which, as I understand it at least, argument has been addressed before now. So that was agreed to and ordered, but there's nothing in the transcript that suggests that there was any consideration by you of why it was appropriate to order that the DIFC documents could be used in Hong Kong and could be used in Singapore and so on. And so we do say that the claimant should not gain a following wind from an order already having been made in that form without argument. The court needs to
there was no
approach.
objection. There was no objection to it.
No, I accept that. I mean, obviously that wasn't the focus of what was happening at the time. We were not. We were focusing on the substantive application, but there we are. The test isn't in dispute. Obviously, it is. It is a situation where the applicant bears the burden. And the Eurov decision, just to take you to that very briefly and identify the relevant paragraphs for your consideration in due course. It's at page 187 of the claimant's authority bundle. What you see is that in paragraph 2 is that it was a post-judgment application for use, and the judgment was a judgment of around $900 million US. And it related to the findings. There were findings made in the judgment. This is paragraph 4, in relation to frauds perpetrated by shareholders. So that there had been a judgment finding that the fraud allegation established. And then importantly, we say at paragraph 42, this is page 193, that the release that was sought was for use in Switzerland and specified countries. That was the nature of the release. It doesn't say in the judgment which countries, but it was specified. And you'll see that at 44, a distinction is made by reference to the ACL Netherlands case. A distinction is made between a final judgment with interlocutory proceedings, where in ACL, I think that the comments made by Mr. Justice Hilliard were really of the kind that made it clear that it was an onerous burden to release from the collateral prohibition, and that was an interlocutory case, as this is, of course. And one of the reasons given for relaxation was that this is paragraph 61 on page 1826. This is that there was a strong public interest in the enforcement of English judgments. So it's a post-judgment scenario, which is very different from our situation. So that's Eurov. And then the other decision I wanted to show you is the SCAT decision. That's actually referred to in Eurov. And if we're in Eurov, we can see that at paragraph 55. It's a decision of Mrs. Justice Cockrell. I think I can say as she then was now, because I think she became a member of the court. Morning, I think. Yes. So Mrs. Justice Cockrell is describing the SCAT litigation at a very early stage, as we know, of course, that was a massive fraud perpetrated on the Danish government, where they were seeking redress for taxpayers, essentially. And there it said there was a very strong public interest in assisting SCAT. There was almost a sort of public element to it. And of course, in SCAT, which was a case I had the fortune to be involved in for a period, there were almost 100 defendants in all sorts of different jurisdictions. So there was an obvious need for the collateral use of documents. But even in that case, and this is the important point, even in that case, the release from the prohibition proceeded incrementally. And so if we come out of Eurov and we go to we go to the SCAT decision, which is on 1971, that's the reference for the hearing bundle reference. What you see is this is a decision of Mr. Justice Bryan. So this is about a year later, because there was a whole slew of preliminary skirmishes.
Sorry, forgive me.
Sorry, 1971.
1971 of your
of the hearing bundle.
Of the hearing. I'm so sorry.
I'm sorry, because I haven't inserted, as I have. It's somewhere like 342 maybe.
I have it. That's okay.
So this isn't Mrs. Justice Cockrell's decision. This is another. This is Mr. Justice Bryan, but it's a year later. It's the same case. And you see on paragraph 10, you'll see this isn't 1972. This is not the first occasion on which relief has been sought from the undertaking. In fact, there have been 3 previous orders permitting the use of information and/or documents obtained by SCAT as a result of the MPOs. That's the Norwich Pharmacol orders.
Yes.
And then it goes on to summarise them. And what you get is, firstly, there were Germany and Dubai preliminary attachment orders. Then it was the DIFC freezing and search orders, and then it was the USA, Dubai, DIFC, and Malaysia, the use of a Deloitte report. And the actual application before Mr. Justice Bryan, you see in 5, is the relevant foreign proceedings. So again, it's specified foreign proceedings. And that was SCAT, and really SCAT is the benchmark, because clearly in that case there was a compelling public interest in use being relaxed, but it was approached incrementally, and so we do say that is the standard position. You don't get a blanket release, and that's where BIJUS in fact goes further than any case that I've been able to identify. Goes further than Eurov, goes further than SCAT, and of course, what is relied on by my learned friend is that this is a fraud case, and we accept that. We're not taking a point about that. We accept that it falls within or under that rubric. But the mere assertion of fraud doesn't open the gates to general release. And you actually see that in the BIJUS case, because there is, to my mind, and Your Excellency will read it in due course, but there is, to my mind, a disconnect between the reasoning in BIJUS and the actual outcome. Because paragraph 95, for example, on page 1744, refers to an incremental approach and reasonableness. And that is not, in fact, what happens, because all of a sudden there has been use granted in UAE onshore courts, it says, but all of a sudden there's general use. It jumps from that to a general use. But then, curiously, in paragraph 108, it says, in the second sentence, on the claimant has made a targeted application for use in proceedings that are closely related in subject matter and parties. But then, of course, if you go to the draft order, it's not targeted in any usual sense, because it isn't limited to specific proceedings, and it's not limited to specific parties, which is what that paragraph of the judgment suggests.
Can you help me with this? And this is because this is what I do have some difficulty with. Is the relationship between the release of the collateral undertaking, and if the proceedings were made public, whether or not then it would be necessary at all to consider the collateral undertaking.
Well, my submission, it is necessary, and it goes to a point that my learned friend mentioned, which is that these documents have been provided in private proceedings. And so you look at the text of the rule, and various comments have been made in cases about how the rule is not as nicely drafted as it might have been, but the text of the rule refers to documents that have been referred to in a, or I need to get the specific.
It's referred to and read
wording
by the court, and that's
in a public hearing.
It is the English wording, isn't it?
Yes, it's but it's in a public hearing.
Yes.
So the leap, I would suggest that concern or issue arises is to say, well, if you make an order that makes everything public, then all of a sudden that means retrospectively that it was a public hearing. And I don't think that follows, because I think you are stuck with the wording of the order of the rule, which is to ask the question contemporaneously: was this document referred to in a public hearing? Whether it can now be released on the basis that you are treating the proceedings as public is a separate question, because I think then, but because there are two stages to it, you still have to ask the question: well, is it appropriate to release the documents that were referred to in a private hearing from the collateral use prohibition?
Yes, I mean, one of the difficulties I think that's always existed with that wording, which is old wording, and probably goes back to the time when people stood up and read affidavits out and the document, whether documents that are not physically read to the court but are on the court file are also open to public scrutiny.
Well, that is a very complex area of law, and technical. And indeed, there was, I recall, an application to that effect in SCAT. I think it was, in fact, one of the applications before Mrs. Justice Cockrell. And clearly, that is not the application that is made. And I think if that were the basis, and indeed what my learned friend has said and accepted, and this is one of the problems, in fact, with the creep that's involved in his extremely widely framed order, is that no, it's not just documents that have been read by the court. It's everything, whatever he means by that. I don't fully understand what he does mean by that, but it's everything in the proceedings, whether or not read by the court. But if he's going to found his application on that basis, and I don't understand that he is making actually that application, he's simply relying on the general permission to release, then he would need to identify precisely, very precisely, which rule he's relying on, which documents have been read, and if they haven't been read or referred to, on what basis they should be released. And none of that's been done. And that's another reason why it needs to be policed carefully, and that's generally the approach, certainly the approach that was taken in SCAT, but it's generally the approach that is desirable. But it's not enough just to say, well, the proceedings are public, it's open season, everything comes out now, because I mean, apart from anything else, that way the court entirely loses control, which I would suggest is not, the purpose of this rule is to allow the court to retain control. Moving on, that's really all I wanted to say on the jurisdiction and how byju's, I think, goes further than what's happened before. But the actual three issues, which are, the first issue is that there's no list identifying the documents, and the authority I rely on for a list is, in fact, it's not a case. It's what's said in Matthews and Malik, and a case is referred to, but it's 2536. Just for your note, I don't think we need to go to it. And it does refer to the Cybron Corp and Barclays Bank case, but you can read that case. I mean, that case does not contain the proposition that a list must be produced, but it demonstrates why. I think Matthews and Malik's point is it demonstrates why a list is desirable, because there was a spat about what documents were involved, and therefore better to have a list so everybody knows what they're talking about. And in fact, Byju's,
do you have a paragraph number for Matthews and Malik? I've got
it's 1947.
1947.
It's the bottom paragraph, and it's the third sentence.
Yeah, okay, that's great.
And so what Baiju says, as my learned friend indicates at paragraph 79, is that the overriding requirement is the documents be described with sufficient clarity and specificity to enable the court to identify the scope of the permission sought. And of course that's true, and you know, one of the ways of doing that would clearly be a list, and we'd say that that's the best practice. But what the problem is the draft order, which is page 16 of the bundle, but because the draft order does not do that. It refers to documents, witness evidence, open bracket, including affidavits, witness statements and their exhibits, and information disclosed or provided by or on behalf of the first defendant in the DIFC proceeding. I mean, that really is extraordinarily broad in terms of its ambit. It's not even just limited to documents. It's any information, and so immediately one is asking the question, well, what does this cover? Even in its current form, even if you say, well, it's everything that's been provided in the proceedings, even on the formulation that's proposed, it's not clear whether it would cover the FTI report and its exhibits. I mean, is that witness evidence? That's an expert report. And it's not clear whether it would cover the memorandum from Campbell's. So
no,
it's not,
but because of the provisos, those could be referred to in Hong Kong and in the Singapore arbitration, couldn't they?
They could be, but whether they have been.
No, but I'm just trying to look at the limitations and what extra is being asked in addition to the use, which already falls within the proviso.
It's actually right. Your Excellency raises a good point, because the original order, which is I don't know if you got it.
I'm sure.
So this is. I mean, I'm now back in the hearing bundle. But the original injunction, the schedule, B6, which is 1105.
1105.
You see, what it says is the applicant will not, without permission of the court, use any information. It doesn't actually refer to documents at all. So, you know, as presently drafted, there is no right to rely on documents. So I don't know to what extent they have been relying on documents.
If information isn't in documentary form, what form is it in?
Well, it's a question of construing the order. I mean, it might be you could refer in a witness statement to information, but you couldn't necessarily refer to the document because it's not there. It's not identified. It is important to circumscribe these orders, appropriately and accurately, and that's why we do have misgivings about the current formulation, and we do say that of course Your Excellency has done a great deal of work writing this judgment, and you've provided the glossary, as I no doubt spent many hours compiling, and that actually does the job in quite a comprehensive way. And one does ask the question, well, if you could do it for the purposes of your judgment, it can't be beyond the wit of the claimant to do a similar exercise of listing out what the documents, exhibits and so on are, so that everybody's clear, particularly when what they seem to be saying is that there's another universe which is not actually what's been provided to you, but exists somewhere else. And again, I don't understand what they're saying there, but it's clearly not satisfactory that is being introduced impliedly within the ambit of the current formulation. So that's why listing out is desirable. The second point is the point about the civil proceedings definition being too broad. There's a balance to be struck. It's about permitting reasonable and justified extensions where special circumstances justify it and there's no prejudice to the disclosing party. And a reasonable compromise is a requirement to identify the proceedings. That's the approach that's taken in the authorities. And it's notable, actually, that Ms. Jabala, in her 6th witness statement, identifies 3 specific types of proceedings. She identifies 1 actual proceeding and 2 contemplated proceedings, the Cayman proceeding, the Singapore proceeding, and the United States proceeding. So she's able to do it. The claimant is able to do that, but she doesn't explain why that there's a need for a wider permission. That's all introduced in my learned friend's skeleton at paragraph 40, and it effectively amounts to, this is a fraud case. We should be entitled to go anywhere we please without notice, and use these documents. And I do not see that anywhere in these authorities. I mean, if there's any case that demonstrates that, apart from this recent DIFC decision, and SCAT must be the benchmark, because there was so much, there were so many satellite proceedings arising out of that case, and each time they had to go back to court as those decisions demonstrate, and that's in keeping with the idea that the extension should be principled and incremental and targeted. And the idea that the claimant needs to bring proceedings without notice is contradicted by the evidence, because they are happy to tell us in their evidence about contemplated proceedings. They're not holding that back. So why can't they tell us when another contemplated proceeding comes to light? They just haven't explained that. If they're going to require and be entitled to this permission, at the very least they need to explain it. It's not enough just to say, well, it's a fraud case. And then the final objection is the point about inquiries and investigations. And again, this is a very short point. I mean, in a way, it may seem like a trifling point because it's just about the wording amongst other things. But really, if you look at that wording, you can see that in effect, what it means is they can use these documents for any purpose at all, for any investigation at all. These are potentially serious matters, criminal proceedings potentially, and it's saying that it may not be related to the complaint made in the DIFC, but it can just be used, and that we say is is obviously objectionable and contrary to the incremental approach that's required, and so those words should be removed. So that's where we are on that, Your Excellency.
So,
and
just, I mean, forgive me using quite a tendentious example, and anybody listening to what I'm about to say should not for one moment consider that I have any idea that this may be the case but I'm just testing the hypothesis. So what if, for example, the claimant were to suggest that your client was guilty of money laundering, and it wished to go to the appropriate authorities, whether Cayman Islands or whether in the UAE or whatever? Are you suggesting that in those circumstances they would have to come back to the DIFC court, essentially ex parte, because they would have tipping off obligations under the statutes, and say, we wish to make a report to the Cayman Islands Monetary Authority or the UAE Central Bank, please allow us to use these specified documents? Would that be the situation in that extreme example?
Yes, I think it would be that clearly they don't there may be an occasion where they're justified in not telling us, and that's why the without notice process exists to cater for that. But it doesn't mean that they should just be entitled to do that generally, to go off wherever they please and to do those types of things. They still need to come before you or whoever and say, well, this is why we need it, and satisfy
so you're
you.
saying we would have, the court should exercise some control in circumstances like that. I see. As I say, I'm not suggesting for one moment that your clients are guilty of money laundering, but I was just testing how it would work. That's all.
So on to the penultimate point, which is the disclosure application. And again, I preface this with the point that for practical purposes, there's not much between the parties. A lot is being said, and I'll come to some of it, that we're in breach, and therefore that's what justifies this application. I mean, we are essentially saying we're not taking a point about your now that you've identified the things in respect of which you say you've identified discrepancies. We're not taking a point about there not being discrepancies at this stage, because we can't answer that question one way or the other, and that will be determined in due course. We're agreeing to provide the information and documentation sought, subject to a couple of points about the form in which that information is provided, and the timing. And so just to update you on 2 points which are relevant context. So just on the form point, there's been one development since the skeletons. We do not have an issue with Mr. Britton providing affidavits. That's obviously been suggested because what we proposed in our draft order is that it's appropriate for FTI to conduct a forensic exercise and produce the information and present the information. But we've also said that that will involve Mr. Britton in that process, that he will be, as one would expect, he will need to give factual instructions if they have queries about particular points. And so what we suggest is that what should happen is that the affidavit should record the matters on which his input has been required, so that the 2 things dovetail. You have the FTI reports, and then you have his evidence, which is going to explain whatever factual information that they've required from him to present the information and explain the information. So that's how we would propose to do it. That as you have seen, we're suggesting 2 phases. You've got a report, phase 1 report, which is dealing with the outflows from the first defendant's bank account, and that would be accompanied with an affidavit when it's produced. And then the second phase is the report dealing with the sums paid to the other Aria entities, and again that would be accompanied by an affidavit. So that's the basic structure. The other point to update on is that that there has been a further witness statement from Miss Ovenden, 6. I don't know. It has made its way into the bundle. I think, yes, it has. I don't know if Your Excellency still got the electronic bundle up, the updated one, but it's at page 2566.
I'll probably have been timed out. Let's see if I can. 2566. Sometimes it doesn't time me out. It's thinking about it.
Well, let me perhaps while it's thinking about it, I'll just explain what it is, because I'm not sure we necessarily need to read it. But this is Ms. Avon just updating on the status of inquiries that have been made of the banks, first defendants banks, but also of the Aria entities, which were paid sums.
I've got it. Yes.
Oh, excellent. So just you will see then that paragraph 7 records that letters were written to the Aria entities on the 1st of October, so yesterday, and they are exhibited in the exhibit, which begins on page 2571. I think there are 10 Aria entities that receive payments from the first defendants' accounts. And so those letters have gone, and those letters show what those payments are in an appendix to each letter. I don't know if you can see an example.
Yes, I've got the first one, the Kiev.
Yes. And so that's the form of these letters that have been sent out. Mm-hmm. And so that the hope is that there will then be engagement from the Aria entities, and they'll be able to come back and provide information as to these particular transfers. That's what's been requested. But no response, unsurprisingly, has been received to those letters yet. And then the second point is paragraph 9, which is updating the position with respect to the banks, what that says is that in effect all the 3 banks are engaging in this exercise. In the case of Mashrek, they've already provided the requested remittance advices, which have gone to FTI. There's an issue was raised by Adib about the form of the request, but that's now been resolved, and EMBD are collating the remittance advices. So there is reason to think that all of the remittance advices we would hope be available soon, and that will allow FTI then to complete this exercise, because it's the remittance advices that allow the missing beneficiary information to be supplied. So that is where we are on that. And then and in one sense, there's limited utility in me seeking to rebut the points made about historical alleged non-compliance. But I think I do need to say something, because it's very much a major plank of my learned friend's submissions. And I just want to make five general points, and I'll make them as quickly as I can. The first is that this is a complex tracing exercise. That there is no doubt about that. Paragraph 14.2 is framed in very wide terms, and it imposed on the first defendant a difficult task of carrying out a tracing exercise over a 3-year period in an extremely tight time frame. And initially, that output was required within 4 working days. We appointed FDI to assist. They were given 6 weeks within a compressed timetable to produce a report. And given the scale of the task, that period of time is insufficient. The time taken by an expert forensic accountancy firm to do this illustrates its complexity. And actually, it's corroborated by what my learned friend says in his skeleton at paragraph 51 about Kroll, because he says that they've undertaken an initial analysis of the payment itemization summary, which was sent on the 7th of August. So that's almost 2 months ago. And they've got through, I think they say they've got through 142 of 478 payments, so about a third. So that just illustrates that these are not straightforward issues. This complaint of delay that we've been delaying is unwarranted. It simply reflects the time it takes to complete a very complex exercise. The second point is the complaint of breach. We do not accept that we are in breach of the asset disclosure orders. It is correct that the court held that the second affidavit of Mr. Britton did not comply with paragraph 14.2.1, and that's in the 19th of May reasons, paragraph 62 and 70. The upshot of that breach was a specific disclosure application that led to the order requiring the first defendant to produce unredacted copies of bank statements. The defendant did that in compliance with the order. And now the claimant complains for the first time that the bank statement was not accompanied by an affidavit. That's paragraph 61.2 of Ms. Jabala's statement, page 40, and complains that payment advices were not provided. That's paragraph 61.4, again, page 41. And now there are sundry other complaints in these schedules by reference to schedules A to F. And my learned friend approaches it today as if the facts deposed to in Ms. Jabala's statement establish a breach. They don't. And Your Excellency could not possibly determine that. It's an inaccurate representation of what's happening. It's the movable feast that Mr. Montague-Smith was referred to repeatedly. We give them something, they say that's not good enough, you're still in breach. But in fact, what's happened is they've waited many months to come back and say, this is non-compliant, that is non-compliant, this is all non-compliant. We've agreed that we're going to answer these points. We're going to look into them with the assistance of a forensic accountant. The fact is that on the payment advices, your lordship, your excellency did not permit them to widen their application in May to include payment advices. They introduced it, if you recall, at the hearing, and you ruled that out. You said that's roving discovery. You're not entitled to roving discovery. And so those weren't produced. But what we did do is we instructed FDI to conduct a forensic tracing exercise in respect of onward dealings. We provided documentation to FDI to assist. That included banking advices. Those were provided with its report. The 529 documents went to FDI, but were not relied on. That included remittance advices. Those have now been provided. That was an oversight. It's not surprising, given the time pressure we were under, I would submit, that type of oversight might happen. We've apologised for it, but we have gone beyond the documentation that was provided in compliance with the specific disclosure application. As I've said, you said at the May hearing that the defendant the claimant is not entitled to roving discovery. Ms. Jabala cites the paragraphs from paragraph 60 in her statement, but she doesn't. She intentionally, but because it's just not there in the sequence, she intentionally omits paragraph 66, which is the point about roving discovery. And what you say in paragraph 60, let's just look at paragraph 66 actually, because I think it's important to understand what was ordered and what wasn't ordered. It's at paragraph 1175 of the hearing bundle. If you've got it, Your Excellency.
Not yet. 1175. Oh, all right. I've got so many bundles open. That's the main original bundle.
Yes, I just did that.
I'm sorry. I have 1175. No, that's the consequentials bundle. 1175 is
The
not
hearing bundle.
When you say the hearing bundle, you mean
sorry, the main hearing bundle.
The original hearing bundle.
The original hearing bundle.
Yes, sorry.
10,000 page.
Yes, then I'm right. Okay, 1175. Yep.
So that's the sequence.
Paragraph 66. Yeah.
Is partly included in Mr. Jabala's statement. Paragraph 66 isn't, and there you see what you say there, that you don't find it acceptable that at the hearing the claimant sought to expand its application beyond the terms of the application notice, and that was the claimant seeking roving discovery to which it wasn't entitled, and it's only entitled to targeted disclosure in order to identify the assets caught by the WFO. And in practice, that means DMCC's accounts for the second to fourth defendant that show the fate of the 6 remittances. So that was what you said, and that, of course, is what we then did. We complied with that. We provided the bank statements, and we then went beyond that by voluntarily providing the remittance advices, which had been analysed to the extent they had been analysed. They were provided. But I mean, another point that this raises, of course, is there's a complaint about ultimate beneficiaries. But another point this raises, we can only show what the bank accounts show, unless we're assisted by other non-party Aria entities. And so when this complaint is made about ultimate beneficiaries, we can only show where the documents take us. And that they won't necessarily take us to the ultimate beneficiaries. I mean, that's just a fact of the documentary trail. But we're doing our best.
Can I just test that? These are sums that your client has paid to someone, right?
Yes.
Okay. Then they must have paid them to that person for a reason. So there will be documents other than the mere bank accounts which will show the reason for those payments. So to say that you can only find out information about the payments from the bank accounts can't possibly be right, can it?
Well, that I don't know the answer to that.
But if I have on my bank account a payment to DEC, the electricity, the water and electricity people for my apartment in Dubai, it will show there's a payment to DEC from my bank account, but equally I can show why that money is being paid because of the bill that they send me, which I'm paying.
That may be right. The point I was making is that we have acted in accordance with the order that was made, and it's very clear what Your Excellency says in that paragraph, that Techteryx is only entitled to targeted disclosure in order to identify the assets caught by the WFO. And then you say, in practice, that means DMCC's accounts with the second to fourth defendants that show the fate of the 6 remittances. Now, That's what we did. That was in accordance with what you ordered. Now, whether there's other documentation, we obviously did then produce other documentation, the remittance advices, which were analysed by FTI, showing identity of the beneficiaries. But whether there's other documentation, I cannot say. But the point is that we weren't ordered to produce that. They didn't ask for that. And to say now, as seems to be happening, well, you haven't done X, Y, and Z, none of which has been asked for when they first introduced this allegation of breach. It's the cart before the horse. That they have now identified in these schedules particular issues, and we're going to go away with the assistance of FTI and look at those issues. But to say that we're in breach by the mere fact of having identified potential issues does not establish the breach. And that's entirely the wrong way around. And the way these exercises happen in practice, because of course, as the Rajan case, which I've cited in my skeleton, there is a requirement for proportionality. You're not expected to identify. You're talking about an asset tracing exercise that involves thousands of transactions. You're not expected to explain every single transaction in an affidavit. Of course you're not, because that would be totally disproportionate. What's expected? But my learned friend says, well, we don't need to engage in this exercise, but that's not how it works. The Rajan exercise shows that yes, the claimant does engage in the exercise and says, I've seen this, I've seen what you've produced. Can you tell me about these targeted transactions, please? And the whole point about Rajan was that they had to go away and narrow their application several times, because otherwise it would have been disproportionate. And so, as I say, we are assisting. We're doing more than we've ever been ordered to do. We're not in breach, and we will continue to assist in a proportionate way, in accordance with our obligations. And so, this criticism is unjustified. To say that our response shows that Mr. Britton is unwilling to disclose the current location of assets and traceable, that is just not supported by the documents that we've provided, and the FDI report that we've engaged FDI to produce. The further reports we're now agreeing that they will produce to get to the bottom of this, to the extent they can. And so we just don't understand the criticism of FDI and this idea that they're engaged in a lengthy, complicated and unnecessary tracing exercise. I mean, surely that is what they want. They want to know the onward dealings. That involves a tracing exercise. Why are they complaining about what FTI is doing and saying it's little purpose other than to delay the final hearing and increase costs? I mean, a tracing exercise has to start at the beginning and proceed by analysis of payment flows. That is the purpose of appointing FTI. And of course, we are conscious of what Your Excellency said about the document dump, and how that was not good enough. We're acutely conscious of that. What we're trying to do is to present the information, to present the documentation in an orderly way that is comprehensible, and that's what FTI did in its report, identifying the gaps, explaining what was required to fill those gaps, and now further work is being done to improve the work that's already being done. So that's really all I want to say. I don't want to descend into the particulars because I can't at this point. But just on the 3 points about the draft order, because I might as well address these now, and then my learned friend can come back. First is the scope of the information, and then there's the form of the information, and then there's the timescale. On the scope, I think the only substantive issue between the parties, this is paragraph 2. So if we look at the order, it's page 15 of the bundle. This is the claimant's order. And the only substantive issue, there is a drafting point I'll come to, but in terms of the actual information, is D, subparagraph D, where it says address and remedy each of the failures to comply with paragraphs 14 to 16 of the WFO. And we say that is the simple objection to that is that it's OTOs, that the effect of complying with A, B, and C will be that the onward dealings will be explained. I mean, obviously, if there's a need to account for a different explanation that's been provided, I'm sure that can be accommodated. But if it needs to be, but the idea that we need to go back and explain apparent inconsistencies, that we would say is disproportionate, because we don't know what they allege are the inconsistencies. And the real objection to all of this, and I'm bound to say one fears it even more, having heard what my learned friend has to say, is that there is a contempt application on the stocks. That's effectively the threat that's been made in my learned friend's submissions. And so what they're saying is, well, address and remedy each of the failures in Jabala 6, lest we come for you with the contempt application. I mean, that is, we suggest clearly on the authorities, which I've cited, that's an improper purpose for a document disclosure order. But that is what that paragraph 2D is.
I think you're right. And I think what I was saying at the paragraph in the judgment that you've taken me to is that we're not at the stage at the end of the trial where we're undertaking a tracing exercise. We are at the stage where there has been a disclosure order in aid of a worldwide freezing order, where the assets have to be identified. So it's a different. I mean, those assets have passed through various hands because it's a proprietary claim, but it's not a full-blown tracing exercise, which would, I accept, take many months.
Well, I mean, that again, that is another concern, if I may say, because I don't really understand what my learned friend is driving at, because on the one hand he's saying you don't need FDI, it's not a tracing exercise, we just need Mr. Britton to tell us. But then he's saying, well, you do need to tell us the onward dealings of all these monies, because you haven't told us. And so that in one form or another, whether it's a downgraded version of the Rolls-Royce event that happens post trial, it is still a tracing exercise, and it's still extremely complicated.
Yes, I mean, I'm going to have to find a balance between the two, aren't I?
Yes, and of course, when you're being told that there's a contempt application waiting, what one frankly is deeply concerned. That's the first time that threat has been made in quite as explicitly. As well, I mean,
it's a Damocletian sword that I think has always been there, but no doubt said to promote your clients to be as frank as possible.
Well, as I say, we don't. I mean, it's not appropriate.
You say we don't need
the threat.
Yeah, I understand that.
So the other, just on the drafting, the drafting point. So it's 2D, and then the drafting point is that what we've done in our draft order is we have proposed substituting the phrase immediate recipient with current location, current whereabouts, ultimate beneficiary. And really the reason for that is to recognize what is happening here and what FTI is doing, because you're starting at the front end of this process from receipt of funds. And the nature of the exercise that they're undertaking is to say what fund payment goes from A to B, the trail goes cold, or possibly it comes back to A again, as is being suggested, and then it goes out again. But really, it's that sequential analysis that takes place, and the trail may run cold at some point. It may not. But to use the phrase immediate recipient it reflects better what is happening than by saying current location, current whereabouts, ultimate beneficiary, because immediately you're faced
what's the
with
reference to your draft? I've got the draft order.
Yes,
the
so
draft order on the amendment.
It's 1385 is our draft.
Thank you.
And the actual, there's a lot of recitals, but then
that's okay, I can work through it.
It's paragraph 2.
Yes, okay.
And then just on the form point, I've explained this. What we're now suggesting is in effect a hybrid form where you have the reports accompanied by affidavits deposing to the facts which are relied on in the reports. And just on the involvement of FTI, because clearly objections being taken to their continued involvement.
I don't think that's right.
Well, I thought it was actually.
I put it to Mr. Holloway that it will be quite appropriate for Mr. Britton to be assisted by FTI, and he didn't demur from that.
Well, I won't deal with that.
No.
Take it. I don't need to deal with that. And then it's just timing, and we can. The point about timing, it's not so much the time required, although that is relevant. It's this idea that you can only structure the time from receipt of these documents. And I think, as I've suggested, there are these two phases. The first phase is the first defendant's bank statements, which we think, the remittance advices, which have been requested, and in the case of one bank have already been produced. There are obviously already the additional remittance advices contained within the 529 documents, which were not considered in the first report. So there's that for FTI to be working on, but to produce a comprehensive analysis, they will need all the remittance advices, and they haven't received those yet. So that's why we're saying 21 days from receipt of the remittance advices. And then equally with the Aria entities, we're saying 42 days for the stage 2 report from receipt of their information, because clearly they're not within our control, and we can't. We can't require them to produce this documentation.
Well, I don't know whether that's true. Mr. Britton in the org charts is the ultimate beneficial owner of the ultimate holding companies of all the Aria entities, isn't he?
Well, we are hopeful that they are. There will be cooperation without.
This is a new issue about non-cooperative Aria entities. When I'd assumed that the Aria group, according to the org chart produced, was ultimately controlled by Mr. Britton.
But I think it may be that I'm not sure it's possible to generalize in respect of each of these entities, because you will recall that there are different groups and
Ukraine I note may be different, because it said that there was a nominee arrangement for I've forgotten the gentleman's name, but
yes,
with
that's
the Ukrainian name. But other than that, from the asset disclosure, I'd understood that all of the Aria entities were ultimately owned by the holding companies.
Well, I'm checking that. I think that the point remains that it is sensible and fair that the preparation of the second report should be linked to the provision of the information, because it will take a period of time for that information to be and documentation to be provided. You know, if there is an issue about that, about it actually being provided, for example, from Aria Ukraine, because it's not under the control of Mr. Britain, then that may give rise to an issue as to completeness of what FTI are able to say, which will become apparent in due course. But the point I'm making is not that this information isn't going to be provided, but that the timetable should be structured so that it runs from the provision of the information. So that's really all I wanted to say about that. I've then got my submissions on costs. I'm conscious.
I mean, we're approaching. Yes, it is 1:30.
Yes.
In Dubai. I think I ought, in fairness to both the Al-Tamimi team and the court staff, take a break. Mr. Holloway, is half an hour good enough for your team?
That's fine with us, yes, Your Excellency.
Yeah. Okay, look, well, let's break now from 1:30 Dubai until 2 o'clock, which will be 11 o'clock for Mr. McPherson and me. Okay, so we'll take a break for half an hour in that case. And you'll come back and you'll do your costs, then Mr. Holloway can reply, and then Mr. McPherson, you can have the last word. Okay, thank you very much. Okay, Mr. McPherson, costs.
Your Excellency, can I come back on one point,
yes,
which was the redemption coupon point, because you expressed an interest in it and raised a point as to whether there's a dispute about whether there have been any coupon payments, and I just wanted to identify that this is a point that was canvassed in the evidence, in the recent round of evidence, and the references are Mr. Balla, paragraph 67.2, which is page 42, where she identifies a apparent discrepancy between payments identified by FTI and those identified by Kroll. And then Miss Ovenden's response is paragraph 36 of her fifth witness statement on page 1377. And that records the position, which is that she doesn't understand Mr. Balla's evidence on the point, because in fact, the Kroll report states that Techteryx confirmed receipt of coupons and redemptions in the amount of $105 million. So,
but we don't know how much was redemption, and we don't know how much was coupon, do we?
Well, not according to that evidence, but that is that is her evidence that it's coupons and redemptions, $105 million. So that's where that appears. So moving on to costs.
Yes.
So we start with this point of principle, which is whether it's appropriate to reserve all costs in this case, and we say it is. The outcome of the judgment is that Your Excellency granted a proprietary injunction in respect of the DMCC payments and their traceable proceeds. That type of injunction is granted in accordance with American cyanamid principles. There is a general recognition in cases in which an American cyanamid style injunction is granted to hold the ring, pending the determination of the substantive dispute relating to the parties' rights. And in those circumstances, it's appropriate for the court to reserve costs pending determination of the substantive dispute. Now, so far as I understand, my learned friend is not suggesting in the ordinary American cyanamid case that it's inappropriate to reserve costs. he's saying two things according to his skeleton, paragraph 13. He's saying that first, that a proprietary injunction is not akin to an American cyanamide injunction, that it's different. And secondly, that a proprietary injunction is a freezing injunction. And he doesn't cite any legal case in support of that proposition. What he relies on is a passage from G, paragraph 1036, which you were taken to. And we'll come on to that, but it does not support what he says. He's also provided a new English authority yesterday, Cancri Investments. And that doesn't assist either because it's dealing with freezing injunctions, not interim proprietary injunctions. And regrettably, I'm afraid, in response, I then added two English Court of Appeal authorities, which I'm not sure you'll be very pleased to hear. But in any event,
I have not read them. There's Melford Capital and Picnic at Ascot.
Exactly. So I'll come on to those. But the reason we added those is that they are referred to right at the beginning of the analysis in Cancri Investments, where, if you like, the starting point is what happens with respect to an interim injunction as opposed to a freezing injunction. And we say that's the relevant jurisdiction in the present case. And the short point is that you cannot collapse the distinction between American cyanamide injunctions and a freezing order at the stage of the costs analysis. So I'm going to address that point first. And my submission will be that the only principal conclusion is that all costs should be reserved. But if you're not minded to do that, then I'll address you on some subsidiary submissions about costs. And the first one of those is that if you don't reserve everything, then you should reserve the vast majority, because the vast majority was devoted to argument about a proprietary injunction. The second submission will be that the unreserved portion, whatever that is, should be subject to a discount. And we say that discount should be 30%, and I'll explain why. And the third submission is that the basis of assessment should be the standard basis, not the indemnity basis. There's no justification for indemnity costs. And then I'll come on briefly to payment on account and release from security. But the first primary submission is that all costs should be reserved. And that's a point of principle. And there are four steps in the argument that I'm making. The first is that there is a distinction between freezing injunctions and American cyanamide injunctions. The second point is that an interim proprietary injunction is a species of American cyanamide injunction. It's not a freezing injunction, according to the reasoning in Unitel. And the third point is that this case, properly analysed, is one where the claimant is seeking a proprietary injunction on American cyanamide principles, not a freezing injunction. And the fourth point is that in the exercise of your discretion, you should reserve. So step one is that freezing injunctions and American cyanamide injunctions are different things. And that's really takes its lead from the Unitel and Dos Santos case, where that was an argument, of course, about the costs of a freezing order application. And the argument being made was that they should be reserved to trial in the same way as would happen with an American cyanamide interim injunction. So the premise of the argument, in fact, was that it's appropriate generally to reserve costs where an injunction is granted on American cyanamide principles. And that same premise was accepted in Cancri right at the outset in paragraph 9. Unitel was not a proprietary injunction case. It was just a freezing order case, and the same goes for Cancri. So they weren't looking at the position that applies with respect to an interim proprietary injunction. And the court held, in the case of a freezing order, that it's not generally appropriate to reserve costs.
That's in Dos Santos.
That's Dos Santos.
Yes. Okay.
It's treated as a conventional interlocutory application. And so you analyze it in that way, and that's in the head note, holding 2. I don't think we need to go to it. I think you've seen.
Yeah.
You've read the passage. You've seen that the passage cited in my learned friend's skeleton.
Yes.
And the effect of that passage, we say, is that a clear distinction is actually being drawn by the Chancellor in as between the two types of injunction. And the important point is that, because it's a point made by my learned friend, is that really American cyanamide injunction is where you have an interim injunction which precedes a final injunction. Now that's not quite right to describe it as that, because what it is, it's an injunction that is granted in anticipation of and prior to a party establishing its substantive right. It's not a right to a final injunction. It's the substantive right which forms the basis of the interim relief. So you're not, you don't fall outside American cyanamide territory if you're not seeking a final injunction. And in Unitel, a clear demarcation is made between the two different jurisdictions, the jurisdiction to grant freezing injunctions and the jurisdiction to grant interim injunctions on American cyanamide principles. And it's accepted that different cost regimes generally apply to each jurisdiction. Now, Cancri is, like Unitel, concerned with the costs relating to a freezing order, not an interim proprietary injunction. And the premise of the argument, and this is, if you've got it, Cancri, paragraph 9.
So where do I find that?
So Cancri is in the bundle at 2553.
Okay,
I've got it
so
separately.
I've got to go to the session timed out here. Okay. All right. Let's log back in. And 2553 is that?
2553 is the first page of the report, and then what I was going to ask you to look at is 2556.
Okay, well, it's just again thinking about it.
Oh, yeah.
2556. Right. Okay, I have 2556. Okay.
Excellent. So that you see right at the beginning of paragraph 9, it says it is common ground between the parties. But the general principle in relation to applications for an interim injunction is that the court will ordinarily reserve the costs of the application until final determination of the substantive issue. So that much was common ground. And the judge then cites the basis of that common ground, which are these two decisions, Melford Capital Partners and Picnic at Ascot. There's also the DECen decision that's already in the bundle at 2174. But it's those two decisions I wanted to spend a moment on, because the proposition is that where an interim injunction is granted, the court will normally reserve the costs of the application until determination of the substantive issue. But then it goes on to say the court's hands are not tied, and if special factors are present, an order for costs may be made, and those costs summarily assessed. And it's really about what are the special factors that allow the general rule to be disapplied. Melford, if I can take Melford first, although it's the more recent decision, and you'll have to move into page 2618 of.
I've got it separately, Melford.
Okay, good. I'm pleased to hear that. That was a breach of confidence claim, and the facts are not especially material for present purposes, but you will see in the head note what is said is that general proposition that where an interim injunction is granted, a court normally reserves the costs until the determination of the substantive issue, unless there are special factors present. Then if you go down to paragraph 35, that's the source of that part of the head note, and it's citing Picnic at Ascot. Then it says at 36 that the short passage accurately represents the law. And then at 37, and this is important, at the last sentence in 37, we do not accept that the so-called pay-as-you-go principle has precedence over the decision in the De Quen case in proceedings for interim injunction. So pay-as-you-go being that the costs are assessed at the stage at which the interlocutory application is determined. And 38 says the court's hands are not tied and refers to the special factors that are developed in Picnic at Ascot. And then 39, the court says that the quest for the successful and unsuccessful party in such cases, interim injunction cases, is usually fruitless. The respondent, like the appellant in the present case, denies the claimant is entitled to any relief because the underlying case of the parties on disputed facts are diametrically opposed. The applicant for the grant of interim relief, even if the court holds that the claimant has a good arguable case or is more likely to succeed than not, the applicant still has to persuade the court the balance of convenience makes the grant of an interim injunction or other related relief more appropriate than its refusal. And then at 43, the court goes on to consider the De Quen case as the source of the modern rule, as to the general position. And then Picnic at Ascot is considered at 44 to 47, and we'll come on to Picnic at Ascot. And then at 49, the Court of Appeal says, we're clearly of the view, as Lord Justice Morrison, Mr. Justice Morrison were in De Quen, that the decision here was unjust in all the circumstances. In this hotly disputed case, in which the underlying issues were impossible to determine at the interim stage, it is right to follow the normal rule emerging from De Quen. We find no special factors indicating a contrary decision. So that is that is how they applied it, the normal rule, because there were no special factors. And then Picnic at Ascot, which is a decision of Mr. Justice Neuberger, as he then was. And this is the special factors case. And have you got that, Your Excellency?
Yes, I have it in front of me.
So there, if you look at the head note, you'll see H4, reserving the costs, say that the claimants have the cost of the hearing in any event. In the absence of special factors, and then it recites the test, the general position. Normally you would reserve, and then the the third proposition at 8.7, there were circumstances where it would be right to depart from the general approach. For example, the outcome of the hearing of the application for the interlocutory injunction might be so plain to the parties that the court could conclude that an order should be made against the defendant for wasting time and money in fighting the issue. And then 4, where the court formed a realistic view that the case was not likely to go to trial and the substantive merits were very plain. And 5, where a claimant had obtained an interlocutory injunction, it was useful to ask whether it would be unfair for the claimants to have their costs of the application, even if they lost at trial, and whether the opposition to the application was justified. So that's how it's summarised, and the actual principles in the judgment itself. If you go to paragraph 7 on page 11, that recites the general rule. And then paragraph 12, where it's permissible to depart from the general approach, where the outcome of the hearing for the interlocutory injunction should be so plain to the parties. That's the wasting time and money point. And then 13 is about the point that arises, and it was touched on by my learned friend, as the impracticality of making an order a cost reserved order, given that there might not be a trial, is that something that means that one should grasp the nettle and assess costs, and that seems to be it can cut both ways, but it's something that may be necessary to bear in mind. And then 14 and 15 are really points about the merits and this idea that really the special factor in an interlocutory injunction case is that the merits are so plain that opposition should never have been taken to the injunction. And the particular point that arises on paragraph 15 is where that might be possible. For example, where the court can take a view on an issue of construction. Clearly, that in essence was the point for Your Excellency, but you took the view that it was too complex to form a view to render it suitable for summary disposal. And then it makes the point that in the case of a disputed evidence, that it's not, the court should be very careful about taking a view, and of course that makes obvious sense, and indeed is the approach taken by Your Excellency in the judgment, that your findings are provisional and only to the serious issue standard. So that's Picnic at Ascot, and really what we take away from that is that the scope for departing from the general rule is really quite narrow, but it's about an assessment of the merits at the point at which the injunction is presented, and if you can't bring yourself within that special factor, then the general rule should apply. And then there's the DIFC authority, Melody and Malance, which I've referred to, and I don't think we need to go to that, but that essentially accepts the general position in American cyanamide interim injunctions that the cost should not be awarded at the point at which the interlocutory application is determined. And what is notable about that case is how trenchantly the court expresses itself and describes the award of costs as being the antithesis of justice. So I would suggest that does indicate that this principle has certainly made its way into the DIFC. and is applied here. There need to be special factors for there to be an order other than costs reserved. The second step in the argument is that a proprietary injunction is a species of American cyanamid injunction, because that is the point that's taken against me, that actually it's a freezing order. It's not an American cyanamid injunction. Of course, Your Excellency will recall that, and you've had to think about it, that there are different tests involved in respect of each type of injunction. And the Madoff Securities case, paragraph 127, which is 9482 of the hearing bundle, that sets out the test for a proprietary injunction which follows American cyanamid principles. So it's clearly
I'm not really sure whether what you call it is the important criterion. The important criterion is whether it is an end in itself or whether it's holding the ring.
Well, we say it's holding the ring in the case of a proprietary injunction, because the substantive dispute, the substantive right, has not been ruled upon. It's not about whether there's a final injunction waiting as part of the relief sought. It's whether the substantive dispute has been ruled upon. Of course, Your Excellency has been very careful not to rule upon the substantive dispute and to leave that to the Hong Kong court. But to deal with the passage from G, because it is obviously the point that's relied on, and it's at 2015 of.
Yes, I have it.
And I mean, the point about this is we're not disputing that as a matter of interpretation of the CPR part 25, freezing injunction cannot include a freezing order in the Morava sense and a proprietary injunction. And part 25 is a procedural rule, and various consequences might flow from that. But it doesn't substantively determine the nature of what is happening when you apply for either type of injunction, and that is distinct.
That's what I meant a moment ago. I mean, this seems to me to be putting form above substance.
Well, that's it, and indeed the paragraph says, you've probably seen it already, but in the middle of that last paragraph, the rules which apply are different. So it is a question of form above substance, and you have to look at what the substance is. So that's what we say is that a interim proprietary injunction is an American cyanamid injunction, to use that shorthand. And the third step is that what Techteryx is seeking in this case, as a matter of substance, is a proprietary injunction. This is a claim about the claimant's right to proprietary relief, and pending the determination of that right, to an interim proprietary injunction. And the worldwide freezing order is there, but it's hanging on the coattails of the proprietary injunction. It's based on proprietary claims, the constructive trusteeship, and the way it's been presented always by the claimant is that this is about a proprietary injunction. There are no freestanding.
Let me put the other point of view to you. The function of a freezing injunction is essentially to secure a judgment. Secure is the wrong word, but it's to ensure that a judgment is not defeated by an unjustified dissipation of assets. So it's to preserve a fund that is available if and when a judgment is issued in favor of the applicant. Now, what is the difference between the preservation of a fund in which it is said there is no proprietary interest, and the preservation of a fund in which it is said there is a proprietary interest.
The difference is that that in the case in which there's a proprietary interest, you obviously have the right to that as in satisfaction of your judgment, in direct satisfaction of your judgment. So it is not about securing an asset for the purposes of enforcement. It is the very relief you're seeking. It's the substantive relief that you have an entitlement to that thing. It's not merely ancillary to the claims. It is the claim, and that's why it's a question of substance, and why what the court is doing is a different thing to what it's doing with a freezing order. And as is said in Unitel, you cannot ever have a final freezing order. And that's why the court can make that assessment, whether the appropriate hurdles have been satisfied at the interlocutory stage, in a way it can't with the substantive relief that is involved with an interim proprietary injunction.
But isn't the proprietary injunction, as sought in the present case, simply seeking to freeze those funds in which it is alleged there is a proprietary interest, rather than establishing the proprietary interest? So in other words, it's like any other worldwide freezing order where there is a claim, and the basis of granting the relief is that the fear that those funds would not be available to satisfy a judgment if and when a proprietary interest was established.
I think there is a nuanced difference between what is happening in each case. I mean, obviously, that is explicitly what is happening with a freezing order, because you are invoking the assistance of the court to personally restrain the defendant from dissipating his assets. In the case of an interim proprietary injunction, what you're doing, it may have that effect, in the sense that you are freezing assets which might be available to satisfy the judgment, but it is distinct, because it is the very thing, it is the very claim, and so different considerations apply. I mean, the question really is in which box does it fit more aptly, and what are the rules that apply coherently to the particular box into which it fits. And we say it is properly analysed. It is about seeking an injunction in support of a substantive claim, where the proprietary element is a fundamental part of the claim. So it is a different thing. But I absolutely accept that it is a nuanced distinction, but that doesn't mean you can collapse the distinction entirely and say it's just a freezing injunction like any other freezing injunction, because that's not what the court is doing. It's having to address the question in a different way and apply a different test. We've seen. I mean, why? I mean, Your Excellency would have seen what I've said in my skeleton about this, but just in terms of this third part of the argument, it's looking as one always has to do when looking at costs, and asking the question, what was this claim really about? And we do say that the whole emphasis of everything has been the proprietary relief, the way it's been presented, the way it's been analysed. It is all about the proprietary relief in support of final relief, and that's why it fits into the American cyanamide box. You then come on to the exercise of the discretion, and you know, of course the court has a wide discretion, but actually in this category of case, the exercise of the discretion has to be principled, informed by this overlay that I've taken you to in the authorities as to the general rules and the very narrow circumstances in which you can depart from those general rules. And what we, in summary, what we would say is first that this is a case about whether the claimant should be granted interim proprietary relief, and that is American cyanamide principles. That's established by a line of Court of Appeal authority, Unitel, Melford Capital, De Quen, Picnic and Ascot. And that authority establishes a powerful presumption that the court should reserve costs in such circumstances unless there are special factors. And Melody and Malance makes clear that line of authority has been incorporated and adopted in DIFC law. The second point is that there are no special factors in the present case. The court did not determine that the merits were so strongly in the claimant's favour to justify an award of an interim proprietary injunction. It was satisfied to the serious issue standard only, including on the issue of contractual documentation. It's not a case where there are difficulties of reconstruction. One of the points that's raised in, I think, the Picnic and Ascot case is difficulties of reconstruction for the trial judge. And that might be a reason why the interlocutory judge should grasp the nettle. And actually, the point that my learned friend makes is, well, this is not going off to the Hong Kong court, or the Hong Kong court is not assessing costs. And of course, that's right. But what the Hong Kong court is doing is effectively providing the answer on success. And so it's not a case where an objection can be taken that the trial judge is going to have a difficulty assessing the costs. And that's why the interlocutory judge should do so, because the interlocutory judge has greater familiarity. Because what's going to happen in this case is that the Hong Kong court will determine the issue, and then it will come back to you for you to determine the outcome of that issue for the purposes of your cost assessment. And I mean, the answer is actually a simple one. It's whether there is a proprietary interest in the reserves. And once you have that answer, it will be straightforward for you to make the cost assessment. It might not happen for some time, but you will have your original judgment. You will have the Hong Kong court's judgment, and you will be able to analyze the two and form a view. So it is an unusual situation, but in effect, the Hong Kong court will be providing the answer on success, and you will simply be applying that. And it's appropriate for the Hong Kong court to be the arbiter of success, because obviously the Hong Kong court has the expertise required to determine the threshold point that you have identified. And you've properly said that everything you say is necessarily provisional. And there are peculiar questions of Hong Kong law that are engaged. So it is right that success should await the determination of the Hong Kong court, because it will be best placed to make that decision. And then there's the point about risk of injustice. There's no significant risk of injustice resulting from the reservation of costs. On the contrary, if costs are awarded to the claimant on what turns out to be a legally flawed premise, then payment will have been made by the first defendant wrongly. And once the outcome of the Hong Kong court's decision is known, it will be too late to appeal. And in the particular circumstances of this case, that's especially galling, because the payment of a substantial costs order will compound the economic harm which is going to ensue from this judgment becoming public knowledge. And we would say that it is an example of what Melody and Malance call the antithesis of justice. And so we accept that, there might be superficially an attraction to the court assessing the issue now that it's familiar with the issues and has heard the parties, but actually the interests of fairness and justice override that practical appeal. There is no practical issue, because the matter on which the Hong Kong court will report is straightforward and will be capable of straightforward application when it comes back to you. and it will provide clarity. And at the moment, the plain fact is that the DIFC court cannot assess the issue of which party has succeeded, because it doesn't have the answer. That's why we say it is appropriate to reserve costs. There are no special factors, and all costs should be reserved until the outcome of the Hong Kong proceedings. And if you're persuaded to reserve, then the best course is to reserve everything, because that will allow the maximum flexibility, and you won't be binding yourself by taking that step. But if you don't accept that, then I do have to deal with the other points. And taking those points, the first one is that if you don't reserve everything, then you should reserve the vast majority. I can see on one view, you could say, well, there was a freezing injunction element to all of this, even if it was subsidiary. Therefore, I should award something to reflect that and reserve the rest. If you are minded to take that course, we do say it should be a very low portion, because there is such a degree of overlap that it's necessarily difficult to separate meaningfully what has happened. But properly analysed, this is about interim proprietary relief. And so we say the discount should be, it should be 90% reserved if it's not going to be totally reserved. The second point is, what about any discount if there is to be a sum awarded to the claimant? What discount should there be on that sum? And we say, we said in our skeleton 20%. Well, I'm actually going to increase my bid, if I may, to 30%, because there are a few other points that have arisen from a learned friend's analysis of the issues of conduct, which I think do bear consideration in terms of an overall analysis of what's appropriate. And I just want to make as shortly as I can 6 different points on why that level of discount is appropriate. And the first 4 of them are elements on which we say the first defendant was successful and for which crediting costs is appropriate. And the last 2 are questions of the claimant's conduct, which we say are sufficiently deserving of criticism that there should be a reflection in costs. The success points, the first 2 I can take together because they relate to the first return date hearing, and they're the fact that the defendant obtained the ordinary business exception to the proprietary order, and the fact that it obtained fortification. And those were points that really were front and centre of what that hearing was about. And I just want to, if I can, take you to the transcript, because if you've got the hearing bundle, Your Excellency, the main hearing bundle, this is.
Yeah. I'll find it. So many open. Where is it? Oh, I have it. Yes, I have the main bundle.
So it's page 1273.
1, 2, 7. Yep.
You'll see right at the top of that page, this is you, although you can't see it, but this is you summarising the scope of the hearing. And we say accurately summarising it, but because what you say is that the defendant was not asking for discharge, but variation in 3 respects. The variation in relation to the proprietary nature, fortification, and directions. So that was what was at play at the first hearing. And the first two matters were really the nub of it, and they were both unsuccessfully resisted by the claimant. And I'll just give you the references, which make that good. It's 1276, 1284, 1400, and 1407. And then the reference to the draft or the order that was made is 1107, and that was the order that made the variation and ordered fortification. And your Excellency says in paragraph 56 of your reasons, which is page 1124, that the focus of the first hearing was argument about the ordinary business exception. As is apparent from paragraph 73 to 74, which is page 1128, the first defendant was successful on both that argument and fortification, and then obviously directions were ordered. So really the defendant wholly succeeded on what it was intending to achieve, despite opposition from the claimant at that first hearing. And clearly the costs of doing that were very substantial, but because of the nature of the hearing, the short notice, the hearing went on for quite some time, as it turned out. So we do say that should be marked in costs, that we were properly characterised as the winner of that hearing, and that should be reflected. The third point is the security for costs application. Now, my learned friend seeks to minimise this, both in his skeleton 9.4 and orally. The fact is that the claimant took a totally unreasonable and unsustainable position on security. It provided no information on its assets despite repeated requests, and then it ran bad arguments to justify no payment based on fortification and the merits. And the court gave those arguments short shrift, and the reference is paragraphs 89 to 109 of your 19th of May reasons, page 1180 to 1186. And we do say that those arguments were misconceived and should not have been run. Security should have been capable of agreement by consent, but instead it became a contested issue, and significant costs were incurred preparing evidence, 2 witness statements on our side, and then fighting the issue. Now, of course, it was one of 3 issues that was the subject matter of the May hearing, along with the disclosure application and the attachments application. But the fact that the claimant was successful on the other applications does not eliminate the first defendant's success. If an order is to be made in respect of costs overall in favour of the claimant, then it's appropriate to reflect the first defendant's success on this issue. It's sufficiently prominent to justify that. So we do say that means it's appropriate to award at least 1/3 of the costs of that hearing to the first defendant. The last point on success is the adjournment of the May hearing on the grounds of the unheralded service of the Kroll report. Just to give you the references again, the adjournment application is at 8992 of the hearing bundle. Now, that needed to be made at very short notice following the service of the Kroll report and the Odgia memo, for which there was no permission. There was no permission was sought in advance for expert evidence. The claimant then opposed the application to adjourn, and that is Ms. Jabala's 5th witness statement, paragraph 3, page 9038, and adopted, we again say, a totally unreasonable position. She suggested at paragraph 37 on page 9043 that the application had been made late, even though it had been made within a matter of days of service of the Kroll report. And so what appeared to be the position was that the claimant was seeking to derive an unfair advantage by bouncing the first defendant into a final hearing without the benefit of being able to respond to this very detailed forensic report. And of course, that would have been contrary to the equality of arms principle. And Your Excellency recognised that and determined the point on the papers. And you say in paragraph 53 of your May reasons on page 1170, I substantially allowed the adjournment application. And I think you use the word substantially because the scope of the permission that we were seeking was slightly wider than what you ultimately granted. But we do say that the opposition to that application was unreasonable and should be marked in costs. And there's another aspect to that, which is that, of course, the 9th of May hearing had to be repurposed at short notice to hear other applications. And that we were very grateful to the court that was able to happen. But what it meant was that it went from a 3-day hearing to a 1-day hearing. And inevitably costs are wasted as parties had to prepare on the footing that a substantive application might be heard of a much greater scale than was in fact heard. And in fact, I can recall not knowing what was going to happen and having 2 skeletons sort of on the stocks because it wasn't clear whether we were going to be fighting the full injunction or a reduced version of it. And obviously that type of uncertainty does lead to duplication. It leads to costs being wasted, and that was a consequence of the late service, or not the late service, the unheralded service of the Kroll reports. So those are the success points. And then if I very briefly deal with the 2 conduct points, the first is one that you'll not be surprised that I mention, which is the full and frank point. We've dealt with it in paragraph 100 of our skeleton. You have found that there was a misstatement relating to the audited accounts. You've described it as unfortunate, and you've said it should not go unmarked. And that's paragraph 3911D to G, 1566 to 68 of the bundle. And in those circumstances where obviously the order hasn't been discharged, the most appropriate sanction is a cost sanction. And that's recognised in National Bank and Euroff, paragraph 18E, which is 2237 of the bundle. And there are 2 aspects to it. There's the fact of the breach, but there's also the fact of deterrence. That it's not just about the gravity of it. It's about that the court has to mark its disapproval in order to deter future breaches. And we do say that there is an uplift for that fact of deterrence. And the court should mark its disapproval with a cost sanction. The last point is about the Kroll report. You did address this in your judgment at paragraph 400. And you referred to the difficulties that arise where a single person or practice is both advising and testifying expert, and that you weren't placing any reliance on any opinions expressed by Kroll, which were not appropriate. And the point about this is that first, that there was no permission to serve this expert evidence. We made our points about it at the time. We had to spend time dealing with it, whether or not ultimately you placed any reliance on it. It raised a whole range of allegations, tendentious opinions, and so on, that had to be addressed. And it also addressed a lot of factual matters not relevant to the dispute, that weren't even developed in evidence after that. Historical matters, smears really about the conduct of Mr. Britton's business. And that's paragraph 23.8 of the report. All of which meant the scale of the exercise was significant to deal with this, and a lot of time was wasted. It's not reflected in the judgment, we accept that, but nevertheless, it is a fact that happened in the course of this litigation, and that should be marked. And so for all those reasons, we do say that, applying a broad brush, that there should be a significant discount, and that it should be 30%, and that's a fair reflection. The third point is about indemnity costs, we say that this is not even remotely close to a case which justifies costs being awarded on the indemnity basis. The principles are clear. It's the circumstances must be such that take the situation away from the norm. For a synopsis, just for your note, the AES Middle East insurance case appears at 1632 of the bundle, paragraphs 25 to 26, just recite the relevant jurisdiction and when it arises, but in effect it's deliberate misconduct in breach of a direction of the court or unreasonable conduct to a high degree in connection with the litigation, or dishonest and inappropriate conduct alleged during and before the trial. That was what happened in that case. I do very briefly want to take you to Pugachev number 2, because it addresses a point which is directly material to one of the criticisms, at least, that's made. And it's at page 2181 of the bundle.
Which bundle?
Sorry, that's the hearing bundle. I'll be able to find the Aria.
2181. I might have that. 2181.
Have you got that?
Yep, I do indeed.
So this case was all about the incidence of costs where there's been an order for cross-examination. So it's a slightly niche, a niche area. But what's interesting about it is the principles in that scenario with respect to indemnity costs, and it's paragraphs 32 to 34. Where the judge, Mr. Justice Hildyard, deals with the general principles. But what in particular he's addressing is where a witness is evasive. What he says there, that mere evasiveness is not sufficient. What needs to be demonstrated is that the individual has actually intended to obstruct justice by giving answers demonstrated to be plainly and obviously false. And the hurdle is a high one, particularly at the interlocutory stage, and the court will be reluctant to reach a conclusion of bad faith and dishonesty, except on the clearest evidence. So that's that. It's an extremely high hurdle. Just before I deal with the specific complaints, just two general points on this. The first is this is hard-fought litigation. In that regard, I'd refer to your own comments in the Albufeira case at 207, and that's page 1665 of the hearing bundle, where you, in that case, you rejected criticisms of a party's conduct as being no more than the usual cut and thrust of hotly disputed litigation. And we do say that when asking whether the circumstances take the situation out of the norm, that is the relevant norm, hotly disputed litigation. And it means that there is a significant margin of appreciation, and conduct has to be truly exceptional to warrant the award of indemnity costs. And the second point is one I've just alluded to, which is that these are interlocutory proceedings. You're not in a position where you've been able to make findings about a party's honesty based on untested evidence. So the threshold is even higher in that situation. But let me then take the 6 matters as briefly as I can.
Apologies for interrupting, and it's just a question of timing. I'm not sure whether Your Excellency wanted to sit late, but my learned friends now had 3 hours of a 6-hour hearing. I've had 1.5, and we've got 1 hour left. So I just wondered if we could perhaps have an indication of whether Your Excellency wants to sit late or how much.
I don't mind sitting to finish, but the court staff obviously has to bear in mind. I was actually considering that neither party would need more than half an hour in reply in any event, and I was assuming that Mr. Macpherson was going to finish about now. Actually.
I'm very nearly done. I just need to address the 6 points, and then
let's see if you can do them in less than a minute each, then, shall we?
Okay. So approach to the evidence. Your criticisms of Mr. Britton's evidence have to be seen in context. They're not findings, they're provisional only. There's no finding of dishonesty. And on the basis of the Pugachev case, it doesn't come close to satisfying the high hurdle. The point about the volume of evidence, that doesn't go anywhere either. And the idea that we could have run a narrow case, and we've really created a lot of work by producing lots of evidence, I mean, that's just totally unrealistic. Of course, a very serious case has been made against us, and we'd be expected to answer it. If we'd said nothing, then no doubt inferences would have been drawn around our silence. So it was appropriate to do as we did. The second point is failure to comply with the asset disclosure order. I've dealt with that. There's been no failure. I've explained that. The third point is delay. Again, I just don't recognise this complaint. If there's been any delay, it's been the cause of the claimant serving late reports. We've acted perfectly properly. There can be no complaint that we sought directions at the first return date. That's perfectly conventional. We needed time, as Your Lordship, as Your Excellency recognised, to prepare our case. The fourth point is the approach to full and frank disclosure. I accept that Your Excellency has made some criticisms of our approach there, but what I do say is that it really wasn't something that featured very much in the hearing at all. It was 5 pages of a 64-page skeleton. It was 45 minutes worth of submission on my side, and it really wasn't a central part of the case. And one of the complaints was upheld. So I think there's limited assistance can be derived from that. The fifth point is the securitization, and it's said that there were persistent attempts to seek to proceed with securitization even after the making of the order, and that's been repeated orally. That's just not the case. There's been no breach of the securitization order. We confirmed we complied and will continue to comply with the securitization amendment. That was QE's letter of the 21st of April. That's 562. The issue arose was whether the fund could comply, and we asked for the court to determine the issue. And it suggested that getting the court's blessing was somehow inappropriate. Well, I mean, the opposite is the case. We were being perfectly open and asking for the court's blessing to ensure that we proceeded correctly, and we respected the decision that was made. So again, I don't understand the basis of that criticism. And then finally, the point about making allegations of dishonesty without evidence. Again, I accept that it's been said that there'd been no evidence to support that allegation. And I accept that it may be said that or it would be said that we overstated matters, but it was a very insignificant part of the arguments being run, and there was reason for making that allegation in the sense that there was evidence to show that Mr. Sun was the person connected who authorised payments. There was evidence that he was the public face, and there was the curious episode about him appearing in the hearing. So it wasn't as though it came out of absolutely nowhere. We felt there was enough evidence to make that allegation. Your Lordship felt otherwise. We obviously accept that, but we don't accept that there was anything more sinister about the allegation that was made. So none of these things justify an award of indemnity costs, and that should be rejected. On payment on account, we're not going to object to a payment on account. Of course, we're not. What we would say, if you're minded to make any order, is it should be 40%, not 50%. 50% is the guideline. We say lower in this case because complex proceedings, obviously numerous different strands and work streams, often overlapping, costs being incurred rapidly and at short notice, and that means there's more scope for duplication than otherwise, and the court should be especially conservative. Particular criticism we would make on the schedule is simply the figures relating to the Kroll report and the Odger memo, which are about 10% of the sums claimed, and they look very high, particularly the Odger memo, which is the same cost as the Kroll report, but it was only 17 pages, so that looks on the face of it unreasonable. So we say 40%, and then that obviously the whatever percentage discount is ordered, that should apply, so that it's 40% of the discounted sum. And then finally, release of security. No, it's not appropriate to release the security for a number of reasons. The first is that the time hasn't elapsed for making the appeal yet. It's next week. I think it's the 7th of October. We're still considering our options, but we haven't made a final decision. The next point is today's order, whenever it's handed down, will be subject to appeal, and there may be significant points around that, particularly with respect to costs. So in short, it's premature to deal with the release of security at this point, and that's really all I had to say about costs.
Thank you very much. Well done. Okay, Mr. Holloway.
Thank you very much. I'll start with costs, given that's where we are, and just a few points. I think that the first point is this idea that in the whole thing, delaying the assessment of these costs to the Hong Kong proceedings, delay in itself, late justice on that, just can't be acceptable here. We've no idea whether there will be any propensity or ability to satisfy the cost judgment at that point. They have protested jurisdiction in the Hong Kong courts. We've not had any indication about whether they will submit to a trial. So that's an open-ended delay and unacceptable. On the definition of freezing order versus American cyanamide interlocutory injunction, Your Excellency is quite right. My learned friend's position is all about form. It's not about substance. I would say he's accepted that the order is a freezing order as defined in the DEC rules. Therefore, it's obvious that the costs provisions that apply to freezing orders should apply to this order for the reasons that are set out in Dos Santos. Not going to go over it again, but it's the free shot principle is the one. You cannot allow people to simply do what the defendants have done here, take every conceivable point and force us to incur costs over a 7-month period on the basis that it might be recoverable 2 years down the line, or if not later. I was just on the case law that he cited. I don't believe a single one of those cases was a proprietary freezing order. They were all classic interim injunctions where the matter would be reserved and the injunction may or may not be made final at the trial. That's very different from here. The Melody and Mallance case, that was a freezing order case. I think this court did indicate that there is a possibility that injustice could be done if someone wins in the end and they aren't able to recover the costs later, but that didn't interfere with the fact that they followed the standard approach in that case. The cost orders were made following the freezing order, and the Court of Appeal, I believe, were not happy with the way that costs had been assessed and referred it back to the Court of First Instance. But that was an example of cost orders being made following a freezing order. I mean, I think my learned friend also accepted trying to draw a distinction between the different parts of this order, one part being the Mareva type order and the other part being the proprietary injunction, the proprietary freezing order. He himself said there's such a degree of overlap that it's difficult to distinguish the two. In effect, that's accepting the fact that this is a freezing order, and both aspects of the order are freezing orders. in terms of the criticisms of conduct, you know, to the extent that you're interested in applying discounts for conduct issues, I would simply submit that all the examples that he's given should be completely sort of counterweighed by the criticisms that I've already set out in the context of indemnity costs. So, you know, the general principle is, yes, there are twists and turns along the road, but there is a clear winner here. That's us. And, you know, we can all engage in post-hearing mudslinging about the details of this hearing. The first hearing, yes, they got the order varied, but they didn't achieve the variation that they wanted, which is that you drop the proprietary aspects of the freezing order. None of this was signalled in advance. That hearing, we'd asked them to set out what they were going to do. They rocked up at the hearing with no applications and sought to attack the order. And they weren't successful in everything they wanted. The hearing was adjourned. Security for costs, we were ordered to pay it and we paid it. That was one of 3 applications, as I've already said. We can really get into the weeds about every single aspect of this, but I would submit that the factors that I outlined in relation to their conduct far outweigh those criticisms. Ultimately, the FTI report didn't help them. The adjournment to get that report in didn't help them. The security for costs, we're going to ask for that to be returned. So really, you've got to take the global picture here. Otherwise, we're going to be re-arguing issues that came up all the way along the way. The Kroll report, you didn't refer to the opinions expressed in that report. You were careful not to, Your Excellency. You were never meant to. I think you've drawn the distinction between an investigatory and a testifying expert. That report was the process of our investigations. I certainly found it very helpful in analysing that vast quantities of data and structuring the things that we felt were inconsistent with it, and not the opinions. Didn't need another expert to reply to that. You didn't need help to separate fact from opinion. And again, the criticisms that they made of that report could have been made without having to file further evidence in response to it. So we still maintain indemnity costs are appropriate, but if you're not minded to do that, we would ask you to take those factors into account in sort of nullifying Mr. Macpherson's sort of plea to have the bill cut down. I'm not going to say too much more than that unless there's anything particular to be said. I think it's all in the skeleton already. I'll just then flip back to the beginning. On privacy, we say that open justice, the principle of it is important, and therefore it extends beyond what's in your judgment. It extends to the documents, it extends to the witness statements and so on. And I think there's really nothing in the criticism that a reasonable person might read any of that and come to unreasonable conclusions. I don't really think the halfway house approach that is proposed by Mr. Macpherson, it doesn't satisfy the open justice requirement, and it doesn't really help his client either, because the conclusions are there in the judgment, and people will draw conclusions from that in a reasonable way. Going on to collateral use, I think just a couple of points on that. If we can look at, I think just, there is no real objection in the principle, so I'll not trot through Baiju's case. because it really does set it out pretty clearly. But one of the criteria there to do with consistency across jurisdictions, and Mr. McPherson said that was something that was in the Eurov case, but is completely absent as a factor in this case. But that's not right, and I think we can refer to your judgment here, Your Excellency, because there are a couple of points where you have marked inconsistencies between Mr. Britton's evidence in this court and his evidence in the Hong Kong proceedings. So I think if I could just refer you to paragraphs 297 to 299 of your judgment, which is at 1530.
Yep.
530. Yeah, so there are 3 paragraphs there.
Yes, I'm familiar with this.
Yes, so you've pointed out there that there are inconsistencies between the accounts given in the Hong Kong courts to the account given here, to do with porting and to do with other things. And I think Your Excellency has been alive to that right from the beginning, from the ex parte hearing when you first read the affidavits. And if I can flick forward to paragraph 341. Again, this is to do with the functional equivalence and the evidence on that, and the idea that payments in. But you said, a possible reading of that is that the impression given to the Hong Kong courts that the 6 remittances were the shares in the normal way. That would be untrue. Now, there was a very, if one remembers, the affidavit in Hong Kong simply said the investments led to shares in the fund. It didn't talk about the porting exercise or any of that, and there were inconsistencies there. We need to make sure in this collateral use that doesn't happen. One of the things that is complained about in the Hong Kong proceedings is that this whole dispute has become fragmented, and it has been necessary to pursue people in different jurisdictions and in arbitrations and so on. And there is scope for inconsistent accounts being given to in different fora, and that's very much a factor of this case. The next just reply point on the idea that everything should be set out in a schedule. Mr. McPherson relied on Matthews and Malik, and he cited a case that was cited there in support of that idea, but as I think he accepts, and I read the case, there's nothing in that case that says that you need to set things out in schedules. So we would rely on the Baiju's case, where that was not required, and I've given you the passage for that earlier. But His Excellency Judge Brendan Lemaire said that as long as you can identify with specificity, clarity, that's what we need to do. Now, just to answer the question that's been raised by Your Excellency about what we do want here, we want the same order that was given in the Baiju's case, that all documents, witness statements, exhibits, and disclosure be made public, and that the collateral use exception sort of extends to those documents. Now, there's been some discussion about what's covered by publicity that isn't covered by collateral use. I think the only thing I can think of are documents that have been disclosed, but that haven't made it into the witness statements. Now, not all the bank statements, for example, have been put into the bundle. That's the only example I can think of at the minute. But what we're seeking is that general permission to use all of the documents relating to these proceedings. Now, there was a query on the draft order and how wide it was. And my submission is, if I can just turn back to that, the draft order on paragraph 4.
Draft order is...
It starts at page 12, so I think this must be page, this is page 16, I think.
Yes, I have it.
I think that any issue that's been raised can simply be solved by the drafting of paragraphs A and B to make it clear that we're allowed to use the documents in proceedings relating to the recovery of our own assets, and that can accommodate any suggestion that there's a completely open-ended permission to use. That there has to be some connection with our attempts to recover the monies, and accept that we can tidy that up in the drafting. But it's already there. It was intended to be already there. I think the brackets, amongst other things, there may be some issue there, amongst other things, but the intention is that those inquiries are connected to the recovery of these monies. Disclosure, then I'll be very brief on, because I think it's just important to make a very simple point here. What the claimant is seeking is the answer to a very simple question, which is, where is the money? Where has the money gone? That's a question that the claimant has been asking Mr. Britton and the first defendant since 2022. And the order, as we understand it, the existing order, ordered him to answer that question. And so the starting point is, again, paragraphs 14, 15, and 16 of the existing order. We're not seeking a disclosure exercise or an audit exercise or a tracing exercise. We're not really interested in a full trail of the money. We need to know where it went first and where it ended up, and that's what Mr. Britton hasn't done. So it's really that simple, and that's what this application is all about. Now, the idea that we have to wait until the other Aria entities agree to supply documents is obvious nonsense. I mean, we've never heard before that anyone apart from Mr. Britton is involved in this. The idea that they've written to the banks yesterday to ask for these documents is obviously clear evidence that they've not been making any attempts to properly answer the question that the order poses. Now, if he hasn't told us where the money is now, and if he hasn't given us the documents that show where the money is, if he hasn't told us who has the money now, and he hasn't given us the documents to show that, then I'm afraid he hasn't complied with your order of the 28th of February, and there just can't be any sensible suggestion that he has complied. Now, so the idea that we have to wait now until the Aria entities at some unspecified future point send some documents to FTI, who take a lengthy period of time to analyse them, to answer these questions, is unacceptable. The timetable my learned friend proposed is an open-ended timetable. We want to given you ample evidence that this order has not been complied with, and in fact, the idea that they're agreeing to give us the information we asked for shows that they largely agree with that. But it just can't be kicked off down the road any further. We need the affidavit to explain what's happened to the money, where it is, who has it, and that's been outstanding for weeks. Now, just from answering your, picking up on one of your questions, I can see, it's true that in May we had made an application because even the bank statements hadn't been supplied. And when we came to argue that, they said, well, we'll give you the bank statements, but we'll redact them. And we did, when we argued the application, go further and asked for the payment receipts. And Your Excellency wasn't minded to order that at the time, possibly because we hadn't included it in the original application. But standing back from it, what good are the bank statements if they don't tell us who got the money? The idea that the payment receipts, they've got them, they have lots of them that they didn't give us, that should have been done at the beginning. Now we're stuck with having to give examples of this non-compliance, and then Malone says, oh, well, we've given you this, now you're asking for more. We're just asking for what was ordered at the beginning. I think Your Excellency is alive to this point. It is a lot more straightforward than it's being made out to be. So that's...
I mean, the position was that in May, as far as I was concerned, I think we did not know whether the bank statements would show the payees.
Yeah, I suppose that's right. But any...
So there seemed to be no point in having the payment receipts if the bank statement identified the payee.
That sounds sensible. I mean, so what we had asked for is payment statements for every transaction over $100,000, I believe, and it may have been in Your Excellency's mind that may or may not be useful. But now we know that there were documents in the possession that did show payees, and we should have got them. But that's just an example, really. That this isn't a disclosure exercise with specific documents. We need to know everything that he knows about where the money is and who has it, and that should be done. It should have been done months ago. It doesn't require a tracing exercise, and the tracing exercise, as Your Excellency said, will follow. And that's what I'll say on that. There can't seriously be a suggestion that he's complied with this order, or we wouldn't be here asking for what we're asking for. Now, can I turn to the amendment application? And I think I appreciate the idea that we can negotiate a word that
it's not a negotiation. I mean, it seems to me, on reflection, that one could read the judgment, and I'm very conscious that it will be read by other courts. So what I said is understand what is undeniably true. It has produced documents for this court. The accepts were fabricated after the event. Now, if fabrication means created in order to deceive, that was not actually what I intended. I did intend created, because I could not impute to Mr. Britton an acceptance that he was seeking to deceive people. I mean, that would be just wrong, because he has not admitted that he intended to deceive people. He's admitted that the documents were created after the event, and so it's not a matter of negotiation. I think it's a fair point.
Well, there are two submissions then, really, that I'd make. The first is the threshold point, and I submit Mr. Macpherson's wrong on this. If this judgment has been sealed under the rules, it's too late to have an amendment of substance. And the cases that he cited were not about judgments which had been sealed they were about judgments that had been either handed down but not sealed, or handed down in draft. And there was
it's going to work. It's going to work one of two ways.
Yeah.
Either I amend the judgment, or in giving this judgment, I am going to say that had I jurisdiction, I would have been minded, after hearing Mr. Macpherson's argument, to change the word fabricated to created, because I accept that it could be read that that Mr. Britton accepted he was seeking to deceive, and he did not accept that he was seeking to deceive. So either way, whatever way you do it, that word is going to be, is going to indicate that I cannot find that he admitted that he was seeking to deceive people. Well, and therefore, I have to use a more neutral phrase.
Then I think just on the law, it's not supposed to have second thoughts, further thoughts. We're not supposed to be re-arguing it. But if genuinely this is a slip and that's what you intended, I can't quarrel with that.
Well, I think it probably was a slip. I did not intend to say that he admitted that he was seeking to deceive people. And I was using fabricated in one sense where it can mean another sense too. I mean, my dictionary has two meanings for it, one of which is created and one of which is created to deceive.
Well, it's an ambiguous word, but I think the reality is ambiguous. And
well,
in a way, you've chosen it quite correctly.
Yes, but then you just read the rest of the paragraph. I don't resile from what's said in the rest of the paragraph. In particular, on the current state of the evidence, it's not easy to envisage an explanation of the various subscription, confirmation, distribution, redemption documents that is consistent with an honest explanation.
Further points to the rest of the application.
Yes, well, and I'll leave it there on that word. Your Excellency, I think that the genuine intention, only you can know that, and it's not for me to say. But the rest of the proposed amendment is impermissible in my
opinion. Yes. I mean that's. I'm not going to start inserting clarifications in this judgment. It's perfectly clear, and indeed the judgment that I issue now will make it perfectly clear that everything in that judgment was expressly stated to be on the serious issue to be tried basis. And any common law court reading that should know that.
In that case, Your Excellency, may I just have a minute to make sure I've not missed anything that my team strongly would like me to say? I'm grateful. Then I'm very grateful. That's all I had to say today. Thank you.
Thank you. Okay, give me 1 second. Right, Mr. Macpherson, do you have much to add after that rather brief reply?
I don't think I do. Let me just run through the points. I'm wondering, could we break just for 3 minutes?
Yes, I'll even give you 5, given that we're not doing too bad.
Very generous.
So it's 12 or 3:53. Let's come back at 1:45. You can have a bit longer, since, and then you'll only be 5 minutes, I assume, when we come back. Good. Sure. Okay. All right. We'll break till 1:45. All right, Mr. Macpherson, anything to say?
I'm sorry to disappoint you, and to disclose I do have some things to say, but I will keep it as confined as I can. So on just a correction on Melody and Malance is not a freezing injunction case. It's a case it's an interim injunction in respect of dealings with shares, where relief was granted on an interim basis pending a resolution of the substantive dispute in arbitration. You get that from paragraph 7, and it's 2103 of the hearing bundle. The degree of overlap. Yeah, the degree of overlap point and is taken against me. The point that I was making is that the freezing order has no freestanding life of its own. It doesn't add anything. There are no independent causes of action which give rise to a freezing order, which is why it's appropriate to analyse it in fact as in substance a claim for substantive proprietary relief. On the point that you should just lump everything together in terms of conduct and then look at who won overall and then make an award 100% in favour of the claimant. That would be unprincipled. This is a case where there are numerous issues that arose at different stages, and it's appropriate to have regard to the different aspects of the litigation. And what we're not saying is that we require an issue-based order. We absolutely accept that would be far too complicated and unnecessary. But nevertheless, in the exercise of your discretion, you can apply and should apply a global discount to reflect the matters I've discussed.
Well, that's what I said in Albuquerque, isn't it?
Yes, indeed. Security for costs, point my learned friend made, apparently in support of his point, was that they were ordered to pay and they did pay. Well, yes, that's correct, but it's everything that came before the order that we object to, and the things that created the costs that we say we're entitled to recover. Those are the points on costs. On privacy, there's nothing to add. On collateral use, I only would say there that a point is made about disclosed documents and a wish for that to be included in the order. Yes. I do say that is fundamentally objectionable, because if you're going to use an umbrella, a compendious phrase to encapsulate a category of documents that has not even been referred to, then it's inherently uncertain to use disclosed documents in circumstances where we're not in litigation where there has been disclosure by list. So it's impossible to know and impractical to identify without a list what those documents are. So it's not the right approach, and to the extent that was the approach taken in Byju's, I think that was a wrong turn, and I would invite you to take a different approach. But all the other points I make stand. Obviously, my learned friend has intimated that various drafting points need to be addressed. Well, we would need to see what they were, but I mean, ultimately that will fall out of what your Excellency decides about the points of principle. What we say is that this should be incremental, and there shouldn't be a general permission. It doesn't matter that a point has arisen about consistency. That arises on the Hong Kong proceedings, and there's already a permission in respect of the Hong Kong proceedings. But even if it were relevant more generally, it doesn't open a gateway to use these documents in any jurisdiction, no matter what. That is all I wanted to say on further disclosure. On collateral use. On further disclosure, it's the point that's taken is it's a simple question: where is the money? And why can't Mr. Britton simply tell us what's happened to it? Well, of course, it might be a simple question, but it's not a simple process to arrive at the answer, because you can't just go from one end to the other without dealing with what happens in the middle. And that's the purpose of the tracing exercise. It is necessarily complex. And what my learned friend seems to be inviting is that you don't need to go through that process. Mr. Britton can simply tell us. Well, he's already said what the existing assets are, and complaint has been made that doesn't reflect what's happened to the monies. So absolutely, we need to go through this tracing process to arrive at an accurate result of what precisely has happened to each line item that's left the accounts. I'm not going to repeat the points about breach. We don't accept in any way, shape or form that we're in breach. I've explained why not. The order required us to produce this information to the best of our ability, and that's what we've done. And we've in fact adhered to all subsequent orders, and we've done more than that, as I've explained. And everything else, everything new, is simply part of a new application. And by agreeing to provide the documents or information or look at it, we're not accepting that we're in breach. We're simply agreeing to comply with the order. So you can't draw any inference from that. Now, the amended application, I don't need to say anything about that. The only other point was just to give you the reference which I've been given for the Kroll report about coupons, because it was something I didn't add earlier, and it's just where Kroll sets out that there was coupon receipt, and it's the main hearing bundle 4817 paragraph 11.8. 11.8. Sorry, one final point going back to costs is this idea that that it's objectionable because it's not even known whether the defendant is going to participate in Hong Kong, and that creates an additional uncertainty. It doesn't create any additional uncertainty. Obviously, if that situation were to come to pass, that would be apparent, and the matter could be brought back before Your Excellency, and a decision could be taken. But it doesn't create any special difficulty. There will inevitably be a delay. Of course there will, but we say as a matter of principle, that is the correct approach, and there are no special factors that dictate otherwise. So unless there's anything I can help you with, Your Excellency, that those are my submissions.
Thank you very much indeed. That was very helpful. Right. Okay. I will have to take a few days to produce my judgment on this. Thank you both very much for very thought-provoking and full submissions, and I will get something to you as soon as I possibly can. Thank you very much indeed.
Thank you.